May Pilot. I did to mention listing in order IA for controlling risk.
Second. You have to make it make a mention before the first bench. Not
Visual with the pencil of other side. I'd like to mention item number 23, 24, 25,
23.
24 and 25 of the supplement. My senior Mr. H.K. Goswami is on leave though. The matter will pick for the next week.
What are these matters?
Madam Lordship, matter pertains to fixation of interest seniority and consequential benefit.
Is it connected with the equity forum case? Equality forum case?
Lordship.
Perhaps I'll not be able to take up, but today we are just adjourning. Item number 23.
24 and 25.
Inform the other side.
Lordship.
Okay. On a prayer made on behalf of Sri S.K. Goswami, Learned Counsel, appearing in one of these cases, matters are adjourned to be listed after a week.
Deeply.
May I please the Lordship? Lordship, I want to mention regarding listing of the matter on Friday, Lordship.
Not
It was
this bench. There's the first bench is there.
Item 22, something before
Lordship, I have the instruction from my client that
Sri V. Kumar, Learned Counsel for the petitioner, submits that he has instructions not to press this writ petition. Who's for central government? Sri S.K. Medhi, Learned CGC, is present. Para? Writ petition is accordingly dismissed as not pressed.
detailed. Item 1.
May it please a lot. First, a correction of date of birth in the service book, my lord.
Okay.
We'll do it.
Yes, what is your case? We
My
can
lord,
go
it's
take up
a-
for final disposal?
Yes, my lord.
Yes, my
Sir, it will take some time, my lord.
No, it will not take the time, but it's simple matter.
You are intelligent, you may not take, I
No, no,
take some time. Move on.
Okay, yeah, good.
Okay. Date of birth, it might take time. We
Yes.
may not take time.
My lord, what happened, my lord? The petitioner before your lordship, my lord, he was appointed as a pharmacist, my lord.
Which year?
In the year, my lord, 02/05/1981, my lord.
2/5/1981.
1981. And my lord, thereafter, my lord, on 04/05/2018, he was promoted as head pharmacist.
18.
18, my lord.
From 81 to 18.
Yes, my lord.
Promoted.
As head pharmacist, my lord.
Okay.
Now your lordship may turn to the writ petition, my lord, page 15, annexure 1, my lord. That is the, my lord, his admit card, my lord, where his date of birth is, my lord, 14 years, 5 months, 19 days.
Mr. Chotia, you can have a seat. 15 is the admit card.
Yes, my lord.
By Seba.
By Seva, my lord. His date of birth is shown as, my lord, 14 years, 5 months, 19 days, as on 1st of March, 1977, my lord.
14 years, 5 months,
19 days.
19 days.
As on 1st of March, 1/3/1977, my lord.
Then his date of birth will be approximately what? Have you worked?
12/9/1960. 62.
12?
09/1962, his date of birth. DOB.
Okay.
But in his service book, my lord, his date of birth was wrongly entered as, my lord, 14/05/1960, my lord.
Service?
Service book, my lord, it was wrongly entered as 14/05/1960.
Yes.
My lord, it seems so, my lord. I think so, my lord. As his date of birth was shown, my lord, 14 years, 05, 19 days, my lord. They have put it, my lord, as 14/05, 1960, my lord. Wrongly entered. So the petitioner made an application, my lord, before the concerned authority, my lord, for correction, my lord, that your lordship will find at page 20, my lord. And page
20.
20, my lord. Page 20, annexure 5, my lord. My lord, I beg to state that my actual date of birth, as per educational certificate and other records of age statement, is on 12/09/1962. But in service book, it is wrongly recorded as 14/05/1960 instead of 12/09/1962.
Yes.
Now, my lord, the director of health service, my lord, in turn, my lord, has referred the matter to the, my lord, the board, my lord, SEBA, my lord, calling for a report, my lord. What is his date of birth, my lord?
Page
My lord, that your lordship will find at page 21.
3-1.
21, my lord.
No,
The director has written to the joint director to
no,
make an
is
inquiry,
it,
my
is
lord.
it 3-1?
Yes, my lord.
3-1-17.
Yes, my lord.
DHS. To joint director
Joint director, my lord. So,
to make inquiry.
inquiry, my lord.
Yes.
Now, my lord, I'm coming directly, my lord, to the report of the, my lord, SEBA, my lord,
Hmm.
which your lordship will find at page 24, my lord.
2-4.
24, my lord.
Yes.
This is a letter from the, my lord, Deputy Director in charge, Board of Secondary Education, to the Director of Health Service, my lord. With reference to your letter cited above, I am directed to inform you that the documents, photostat original of the candidate, which you sent for verification of so-and-so, is here are verified and found as shown below against the name as per the records of this office, my lord.
Hmm.
Samsul Haq Borbhuya, my lord, lordship will see, year 1977, HSLC roll number so-and-so, my lord. Age, my lord, as on 01/03/1977, 16 years, 5 months, 19 days, my lord.
Hmm.
Then again, my lord, another report came that is at page 26, my lord.
26.
26, my lord. Here, my lord, same thing, my lord, but lordship will see, my lord. 7th column, my lord. Here, my lord, it was correctly stated. Age on 01/03/1977. 14 years, 5 months, 19 days, 19 days, my lord.
No, in the initial, why is that stated in 16 years?
Initial, it is stated at page 24.
Why 16 years?
16 years according to them, my lord. But subsequently, they said, my lord, at page 26, it is 14 years.
F4. F4 18.
So at page
Just a minute, just a minute. F4. In the second subsequent letter of 5/4/2018,
yes, my lord.
what is the explanation regarding the earlier letter of 3110?
My lord, earlier they stated, my lord, it is to be 16 years. Subsequently, my lord, they have stated it 14 years, 5 months. My lord.
No, that is okay. That we have seen.
Yes, my lord.
But when one communication was issued,
Yes, my lord.
putting a particular date of birth,
Yes,
that may
madam.
be erroneous.
Yes, my lord.
But in the second communication, there has to be a reference to the first communication.
Yes, my lord. That is your, my lord, reference, your letter number, so and so,
No,
my
no,
lord.
that is not the reference. The reference should be with 31/10/2017. Has been anything been said about 31/7/2000, 31/10/2017?
No, it is not referred, my lord. In the subsequent, my lord, page 26 is not referred.
Reference is same letter. Reference is made same letter, page
No,
24
no,
and
we are not on that.
26.
When 5-4 is 18 is obviously subsequent to the first letter of 31-10-17.
Yes,
So you cannot have two stands.
yes,
Either one stand or this stand, but if you are making a subsequent letter,
yes.
you have to make a reference to the earlier letter that it was erroneously issued or something.
Nothing.
Why page 26, this letter was issued? That is
Yes.
the question. I have
Yes.
the output.
Yes.
Now, my lord,
Just a minute, please. Okay.
now page 29, my lord,
29.
29, my lord.
Yes.
Again, the director of the my lord health service requested the deputy registrar again to clarify the position, my lord.
Yes.
Well, with reference to letter quoted, I have to inform you to say that 2 letters have been received in this directorate of same subject matter and the same query in compliance of our letter dated so and so.
Hmm.
In your letter dated 31-10-17, the age was shown as 16 years, 5 months, 19 days on so and so. And in the letter dated so and so, it was shown as 14 years, 5 months, and 19 days. As the matter has created confusion, you are requested kindly to intimate the correct position. The photocopy of the so and so has been entered. So again, they had sought for a clarification.
Correct.
So thereafter, my lord, while pending of this application was pending, my lord, I was superannuated, my lord, and a retirement notice was issued, my lord, that your lordship will find at page 30, my lord. And as per that wrong date of birth, I was, my lord, I got my lord, retired, my lord. I am to inform you that as per service book, date of superannuation is fallen due on 39/20 and after afternoon attaining the age of 60 years. My lord.
Yes.
My lord, my lord, they have filed an affidavit, my lord, in this case, my lord, that is 2011, my lord, 2011-20, my lord. There, my lord, they had stated, my lord.
This is the order you are challenging to.
Yes,
26 at page 30.
yes, my lord.
Okay.
Now they have filed an affidavit in this case, my lord.
Seba has filed.
Seva has filed. That is on 2011-20, my lord, as per Land Administrator. In that paragraph 2, my lord, they have stated, as per the order dated passed by this honorable court, the deponent has been directed to place the copy of the MRS submitted by the head of the institution of so and so school at the time of appearing in HSLC examination 1977 and tabulation register sheet on record in the form of affidavit, my lord.
Hmm.
There also, my lord, they have taken the stand, my lord, paragraph 3, my lord. The deponent begs to state that the petitioner had appeared in the high school leaving certificate 1977, roll number so and so, as per the statement of particulars of candidates submitted by the head of the institution at the time of appearing in the state examination. Date of birth of the petitioner was recorded 16 years, 5 months, 19 days as on 1/3/1977. Last proper, no?
Page 3.
While this case was, my lord, heard in the court, my lord, and a hearing was going on, my lord, then, my lord, the Seva authority, my lord, filed another affidavit, my lord, wherein now, my lord, they have taken, my lord, as a ball step, my lord, in paragraph 3, my lord, that is the most important thing, my lord. That is at page 55, my lord, serially, my lord, page 55. Don't you have found it?
55.
55, my lord.
Yes.
Paragraph 3, my lord. That the deponent begs to state that the font of the typing in the name of the candidate as on 1 March 1977.
Page, paragraph?
Paragraph 3, my lord.
This is the second affidavit by
Second
statement.
affidavit.
Additional affidavit.
Additional affidavit. Additional. The deponent begs to state that the font of the typing in the name of the candidate is as on 1 March 1977, father's name as well as roll number reflected in the admit card being office number so and so produced by the petitioner are not matched, and similar type of font with the actual font of typing of the particulars of the candidates prevailing in the board at the time in the admit cards issued to the other candidates appearing in the HSLC examination 1977. As per the norms prevailing in the board in the year 1977, the admit card issued to the candidates appearing in HSLC examination 1977 were countersigned by the officer in charge of the center of examination. But there is no counter signature of the officer in charge in the admit card shown to be issued to the petitioner as produced by him. My lord, now they have questioned, my lord, on the last occasion, my learned friend said, my lord, the admit card which I have annexed in the, my lord, writ petition is a vague, my lord. This has been created by me and this has been manufactured by me, according to their stamp. So, in reply to this, my lord, I have also filed an affidavit, my lord. Their claim is that, my lord, at page 56, my lord, your lordship will see, my lord. 50, my lord, it starts from 55, my lord, paragraph 4, my lord.
Yes, we have seen this.
That the deponent so and so in regard to the HSLC part certificate dated so and so under number so and so produced by the petitioner, it is detected that the font of typing of the petitioner name, roll number, as well as division in the said pass certificate are not matched with the actual font of typing of the particulars of the candidate used in pass certificate issued to the candidates who had passed in HSLC examination 1977. Moreover, it is also detected the serial number so and so printed in the pass certificate produced by the petitioner is found to be computer printed, whereas the board used to print serial number in the pass certificate by a special machine. It is also found that below the left side of the pass certificate produced by the petitioner, it is written as Guwahati, G-U-W-A, Guwahati, Assam. But at the time, the name of the Guwahati existed at that time, my lord, in the documents of Cheva. In the similar certificate during the period of petitioner appeared in the HSLC examination 1977. The word Guwahati is existed and not Guwahati. Perhaps the petitioner, while making his pass certificate to be shown as genuine pass certificate, these are not noticed which have been detected by the board. Hence, the pass certificate produced by the petitioner as original is not genuine certificate, rather it is a self-made fake certificate. The serial number may be used by the petitioner from the original pass certificate issued by the board. Hence, it is fact that the admit card as well as the pass certificate produced by the petitioner were actually not issued by the board. My lord, I have filed and replied to this affidavit, my lord.
Which page?
My lord, page 61, my lord. We have annexed one, my lord, another certificate of another person, whereas also it is shown as, my lord, Guwahati. But the problem is that, my lord, suppose, my lord, if a person passed in the year 1977, if that person makes an application to the board, my lord, for issuance of a certificate or a pass certificate, admit card, my lord, now, my lord, in the year 24, my lord, there in the, my lord, font, my lord, they will put, my lord, Guwahati, not Guwahati, because now it is Guwahati. So the present petitioner had filed an application to the board for issuance of a certificate later on.
Why later? What happened to the admit card?
Admit card is genuine. Pass certificate. Admit card is generated. Admit card is generated. And I have the original admit card and the pass certificate. If your lordship pleases, my lord, if he wants also, my lord, that can be sent to the forensic, my lord, and verified it.
Let us see where is the other certificate where you have.
Page 66, my lord.
Here is Guwahati is written. It is Guwahati, GAU is
Yes,
written.
GAU, my lord. Yes, my lord.
In our admit card of board.
In our admit card also it is Guwahati. Our admit card, your lordship, in the writ petition at page 15, my lord.
No, why have you annexed somebody else's to show what?
So may I point you one thing?
We'll come
No, no,
to,
no, no,
we'll come to, we'll hear in details. Why have you annexed somebody else's?
My lord, because, my lord, that was a question raised by him, my lord. They submitted, my lord, we are fraud, my lord.
No, this certificate is of the same year or roundabout,
Yes,
but
my
it does not have the expression GUWA. It has.
no, my lord.
So how does it help you?
The font is same, my lord. That's what I have to say, my lord. They are raising the question. The font is appointee, my lord. Font is not same. My lord. My lord, page 62, my lord. Second paragraph. In the instant case, the deponent is a resident of Hailakandi district and appeared HSLC examination from Deshbandhu Vidyapit HS School, Hojai. However, after completion of his HSLC examination, he passed 2 years 2 years of pharmacy course under Assam Medical College in the year 1981 and came to his house district Hailakandi and subsequently got the job in the health department. In course of time, the deponent never felt necessary of the original HSLC certificate in as much he had fulfilled all his requirement with the provisional HSLC certificate issued by the school immediately and after passing of the HSLC exam. In the year 2015, when he found that his provisional HSLC exam certificate has been missing, lost, he rushed to the so-and-so school Hojai to collect the original HSLC certificate. But unfortunately, he was informed from his school that since he did not collect the original certificate for quite long time, the school had returned back the same to the board. Thereafter, the petitioner approached the board and on his approach, he was asked to submit an application in this regard. Accordingly, the petitioner submitted an application and paid rupees so and so as necessary fees, and thereafter the petitioner was issued the original certificate within around 2 months from the date of his application. The petitioner cannot remember the exact date of the issuance of the certificate, but it was issued in the year 2015. And since the certificate was issued in the year 2015, the word Guwahati might have been used in as much as because at the time of the board stating using Guwahati instead of the Guwahati.
No, but it is okay. But this signature is of the same gentleman, secretary, at page 16. It is not a duplicate certificate. Mr. Chutia, page 16. Page 16.
Yes.
He says that Guwahati GUWA is written,
Yes.
but the date is 77 and see the signature. More than that, it is same as Bharali, who was the secretary in that period, 77.
Yeah, yes, as probably, but I will, he finish, let him.
No,
finish.
I'm just,
Oh, yes,
we'll come to you in details.
yes, yes, Lordship.
How do you explain this?
Lordship will get the other original one, he will produce it today.
Original.
Yeah.
Now, how as Bharali will sign?
Nothing else, my lord. How it manipulated, I will come to the even here.
The signature will be there, it will be written
Yes,
as SD or something. If
No,
you
no.
are using a duplicate or at a say later point of time.
But this is the original.
They, how they are doing it? How the manufacturing factory is there is the own, my lord, not to be revealed today.
Factory.
Yes, I will agree. Because of Kali say, original, or it could be a-
No, I'm just, we'll come to you in details. Yes, yes. 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 We'll come
Yes, Lordship, kindly see their affidavit reply. No, my lord, affidavit reply against additional affidavit, my lord, page 66. This is genuine. But to kindly see, page 66. And page 16 is a writ petition, is a petitioner's.
Mr. Datta, how Mr. Bharadi will signature will appear?
That's why there
was
is
my
factory,
instruction.
very well, a special factory.
My lord, if your lordship, my lord, please, my lord, can I have the client to come in Guwahati?
No, no, my lord. Yes, that can be, my lord.
That can be, my lord.
No, no,
If-
today, I'll compare. But let me say, my lord,
Yes.
Lordship, page 66.
Now, after Mr. Datta completes, we'll
Yes.
we'll complete this.
Let him complete, my lord.
My lord, that was my instruction, my lord.
No,
So,
that is
my lord. And so far, my lord, if your lordship pleases, my lordship may keep this matter as part. I have no problem. I'll call him, my lord, day after tomorrow also. My lord.
no. Why should you call
My
him?
lord, that clarification, my lord, that was my part.
Record shows, my lord.
We will not interact.
Yes, my lord. And one more thing, my lord. If
You
the-
you are representing. You are doing more than what is necessary. You are placing all the facts. That is okay. Fair.
Yes, my lord.
What else?
And in fact, my lord, if this is not the certificate, my lord, if this is not the pass study, this is not the admit card, my lord, from the record shows, my lord, why have been given that certificate, my lord? And if that number is not me, then to another person, my lord.
Guwahati connected. Guwahati package में कितना? Right. Thank you.
Hmm?
Guwahati signature कितना है?
And if they subsequently the delay 70,000. Okay. My lord, what have been instructed by my friend, my lord, the seals are ready-made, my lord. In the years when so they put the seal, my lord. Now, if this is not mine, my lord, 00022591, my lord, then whose that serial number goes to whom, my lord? That has to be clear.
कितने तो बता पहले मैं
And why your admit card does not have the counter signature of the OC, officer in charge?
Huh? That was not there, my lord, that part.
Actual date of birth is not put there. That's why not there.
अच्छा.
No, Mr. Chutia, even if you discard the pass certificate,
Yes.
so far as the date of birth is concerned, for the moment, let us assume, and there is no past certificate. He comes to the court with the admit card. Admit card has 14.
That's why like, no counter signature is there. Because that was made by them. That is at that moment, my lord, what happened? Only we keeping blank on this thing, my lord, the SEBA issued certificate and the officer in charge, they fill up this as per records of the school admission register. And whatever they have recorded, that has been statement sent to us.
We will come to, yes, Mr. Dutta, anything
Well,
else?
so far this counter signature is concerned, my
Yes,
lord.
yes.
Well, my learned friend says he's admitted there is no counter signature. I have to go to my home, my lord, to see, my lord, whether the counter signature is there or not, my lord. My admit card, my lord. And the other person which I have annexed, my lord, there is also no counter signature, my lord. That at page 66, my lord.
Mr. Chaudhary, you can take the example of other person. Don't take your example. You may be in difficulty tomorrow. So better to keep quiet. Otherwise, you may seek your certificate also. Don't take that risk.
I have to see my certificate, my lord, today.
Admit card.
But the other person that I have annexed, my lord, at page 66, my lord, he has also no counter signature.
Other person, page.
Page 66, my lord, in my additional affidavit, my lord, to reply, my lord. Page 66, my lord. Admit, sorry, page 65, my lord. Annexure act.
Hmm.
There is also, my lord, no counter signature, my lord.
Okay, anything else?
And my lord, the affidavit, my lord, which they have filed, my lord, that is 2011-20, my lord. Page 2, my lord. Paragraph 3, my lord. Lordship, found it, my lord.
Just a minute, please. Page, page
Page 2, my lord, paragraph 3, my lord.
of running page.
That is, my lord, earlier point of time, my lord. 2011-20.
Affidavit of?
Affidavit of respondent number.
Yes, page 31.
Yes. Paragraph 3, lordship had found, my lord.
Paragraph?
Paragraph 3, my lord.
Yes, you have read those.
Yeah, the deponent begs to state that the petitioner had appeared in high school living
Yes,
certificate.
we have read this.
Lordship had found, my lord. Yes, my lord, that is the, my lord. As per the statements of particulars of candidate submitted by the head of the institution, my lord, this part, my lord. At the time of appearing in the said examination, the date of birth of the petitioner was recorded 16 years, 5 months, so and so, my lord. Now, if the lordship turns to page 4, my lord. page 4, my lord, the tabulation register, my lord.
Hmm.
1, 2, 1, 2, 3, 4th, my lord. The name of the petitioner, my lord. 0346 Mohammed Samsul Haq Borbhuya, my lord. Lordship found, my lord.
Yes.
My lord, lordship see, my lord, 87, 87B, pass, my lord. So their submission is, their affidavit is that, my lord, at the time of appearing in the examination, this register was there. But already, I think this was prepared after he passed, my lord. That's why that P is there, my lord. Above that, my lord, your lordship will find failed, my lord.
It is not failed. It is H.
No,
Is it-
above, my
it
lord.
is Persian. Persian and Hindi.
No, no, my lord. If your lordship sees, my lord, third one, my lord, 0345 Somir
Yes.
Kumar Bonik, my lord. Son of Shankarlal Bonik, my lord. Lordship will see, my lord, last, my lord, fail.
Fail.
Fail. Now here the present petitioner pass, my lord. Division 3, my lord.
After the results.
After
obviously,
the result. And
This is
but it-
tabulation register. Obviously,
Yes, my lord.
after the
And
result.
they have stated, my lord, that is at the time of preparing the, my lord, while he was appearing. My lord. That much, my lord.
Page, let us see again. Annexure 3, what they have stated.
Page 4 is the tabulation, my lord.
Yes, tabulation.
Yeah.
One, black one.
No, that is not the meaning, Mr. Dotto.
Yes, my lord.
It is at the time of preparation of the tabulation only.
Yes, ma'am.
The-
This
Page
language is, my lord.
Now, as per the statement of the particulars of submitted by the head of the institute at the time of appearing of the date of
At the time of appearing the said examination.
Yes. But this is tabulation form, doesn't
Yes,
it?
yes,
Not
madam.
make a difference.
That much, my lord.
Okay.
And if I, my lord, if my date of birth is to be held to be correct, my lord, then, my lord, there will be, my lord, 2 years, 4 months, my lord,
Of service left.
service left.
Okay. Yes, Mr. Choudhury.
Yes, my lord. My please, Lord. My lord, Lordship, I am starting where he is ending, my lord. Ending point. Lordship, kindly see page 3, MRS. This is not made by us, but now type is by digital. It is done in the office of the SEPA. His date of birth, his age is, my lord, 16 years, 5 months, 19 days. That is his Samsul Haq Borbunia. That is the original. His date of birth. And on the basis of that, we issued the certificate. That is our first affidavit. When we first filed this first affidavit, my lord, then he produced the original one. This colorful one, my lord, one romantic color is there. I have seen it, my lord, this certificate.
What
This
is-
color is not.
What is romantic color?
That is not, can you see there?
We have heard of red,
Pink,
blue,
like that,
yellow,
pink,
green,
pink color.
romantic color.
I have not seen like that, my lord. I always said we are color is
This
not
one?
like that. Yes. Sir. So he produced this that one before this court after filing this affidavit, and thereafter what happened? We have to
You may
file.
have romantic colors. The doctor doesn't have romantic colors.
He is client, my lord. So my lord, what happened, my lord? Thereafter court
My
asks
lord,
us.
can I have, my lord, 5 minutes? My lord? What? Sorry, my lord.
So court asks us, you clarify it whether it is a genuine or not. This one matter.
Okay.
Then we file the additional affidavit. Lordship, kindly see our additional affidavit.
Page.
File on my lord 53, page 55. Lordship,
Five.
kindly see 55.
Just a minute, please.
55, paragraph 3.
By Narayan Nath.
Yes, Notional, not. The deponent best, Lordship, has your Lordship got it?
Just a minute, please. 54. Yes.
Page 55, paragraph 3. The deponent expressed the font of typing of the name of the candidate as on the 1st March of 1977, father's name as well as roll number reflected in the admit card being office so and so produced by the petitioner are not matched, and similar type font with the actual font of typing of the particulars of the candidate prevailing in the board at the time of admit card issued to the other candidate appearing in the SSLC examination 1977. As per norms prevailing in the board in the year 1977, the admit card issued to the candidates appearing in the SSLC examination 1977 were countersigned by the officer in charge of the center in charge, but there was no counter signature of that in the admit card. And later part, Lordship kindly see paragraph 4. The deponent begs to state that the HSC pass certificate dated 27/6/1977. The pass certificate we issued that time. The serial number so and so produced by the petitioner. It is detected that font of typing of the petitioner name, roll number, as well as the division in the said pass certificate are not matched with the actual font of typing of the particulars of the candidate used in pass certificate issued by the candidates, issued to the candidates who had passed SLC examination 1977. Moreover, it is also detected that serial number so and so printed in the pass certificate produced by the petitioner is found to be computer printed, whereas the board issued to print serial number in the pass certificate by special machine. That is the point, my lord. We have keeping some secrecy. How we will print it? If it is released, that everybody can print. Our print is a special print in the board. Is every examination conducting board, my lord, keeping this print. I will show it, my lord. Especially it is, my lord, printed. Now petitioner, I will compare to that it is, my lord. It is also found that below the left side, the pass certificate produced by the petitioner, it is written as Guwahati, Assam. But at the time, the name of Guwahati, like Guwahati High Court, existed in the documents of Sabha. In the similar certificate during the period of petitioner appearing in SLC examination 1977, the word Guwahati is existed and not Guwahati. Perhaps the petitioner, while making his pass certificate to be shown in the genuine pass certificate, there are not noticed which have been detected by the board. Hence, the pass certificate produced by the petitioner as original is not genuine certificate, rather it is a self-made fact certificate. The serial number may be used by the petitioner from the original pass certificate issued by the board. Hence, it is a fact that the admit card as well as the pass certificate produced by the petitioner were actually not issued by the board. And now, Lordship, kindly come to the front. What is front and what is not front? Lordship, kindly see the page 66, first of all, his document, page 66 of his affidavit in reply.
66.
66.
Yes, please.
And his read petition, page 60, two
One-
certificate. His certificate,
16.
16, and step 2. I'll compare this.
Page 16.
16, page 16, and step 2. He is claiming this certificate is genuine. That is before your lordship.
Yes.
Look at seriously, lordship, can you see the original one, page 66.
Yes.
This is the correct certificate. Font, lordship, can you see the letter, the printed letter, and below that.
What
and
is the
roll
name
number-
of the name of the petitioner?
Yeah, I've come to that defined.
No, 66 is his name.
66, no, he defined. He defined certificate. They have issued it. They are showing that this certificate also showed in the Guwahati.
Okay.
Guwahati and Guwahati, this is a different thing. Lordship, can you see? The font of typing, lordship, say our letter. Numerical and letters. And lordship, 1977, lordship, can you mind it? 77 is long. 1977, lordship, can you see page 66? 1977, 77 is long. 77 is long.
Yes.
Lordship got it. And his fact certificate, lordship, page 16, lordship, this. He's type right. In computer, he cannot make it. That's it defines, 1977. It is short. It is computer printed. And this original printed is 6677, lordship, can you see? Long. And Guwahati. Left side Guwahati. At that moment, there was not Guwahati. And he is Guwahati. Because after filing of the additional affidavit, they are vomiting, How is vomiting? I am saying, lordship, kindly see page. This is a simple comparison, Guwahati and 77. And therefore, lordship, kindly see paragraph. Yes, page 5, paragraph 3. And it will be
Of the repetition.
read petition. And also, lordship, simultaneously, kindly see paragraph 3 reply, no? Of 62. Yes.
Page?
Page 5, paragraph 3, Lordship kindly see.
Yes.
The history. The petitioner begs to state that he came successful in the said SLC examination 1977 by securing 3rd division. Thereafter, in due course of time, that is, the board issued original certificate, pass certificate in favor of the petitioner, which he collected from the concerned school from where he appeared the said examination. That means due course means board issued certificate 1 year or 2 years, not located. He collected, he admitted collected. In the HSL certificate, the age of the petitioner was also recorded 14 years, 5 months, 19 days as first past and 77, which is I don't know. The petitioner also obtained diploma so and so. Next Lordship kindly see. He paragraph 3 say he collected it in due course of time when he passed 77. That means 78 he collected. And now page 61, 62. Second paragraph, Lordship, paragraph 3, the additional affidavit in reply filed by them. No? No. Yes, paragraph page 62. Paragraph second paragraph, Lordship kindly see. Has you got it, Lordship?
Yes.
Second, in the instant case, the deponent is a resident of Hailakandi district and appeared SLC exemption from the Dasbandhu Vidyalaya Higher Secondary School, Khudai. However, after completion of his SLC examination, he passed 2 years pharmacy course under Assam Medical College in 1981. He came to whom district so and so. Next, in course of time, the deponent never felt necessity of original SSLC certificate as he had fulfilled his all requirement by a provisional certificate, handwritten certificate, issued by the school immediately after passing the SLC examination. In the year 1915, when he found that his provisional SLC certificate had been missing or lost, he rushed to the Dasbandhu High School, Khudai, to collect the original SLC certificate. But unfortunately, he was informed by the school authority that since that he did not collect the original certificate for quite long time, the school had returned back to his home. That is his malot. Abul Tabul, what is called in Assamese malot, started. His own statement. His petition, he want to establish that fact certificate is a genuine. When we inquired it, it is not genuine, it is made by them, their own factory, then they started saying like that Guwahati. That was in the act that Guwahati as Guwahati and Guwahati, when it came up, Lordship kindly see. 84, Lordship kindly see. 83 the last Guwahati, 84 from 90 Guwahati. In also some nameplate also in the institution they come Guwahati. And they are saying Guwahati is not. That is our findings. We have verification. Lots of kindly see. Last 83, the Guwahati, TAU, and 1984 start Guwahati, writing Guwahati all certificates. And these two statements only sufficient, my lord, to dismiss the writ petition with exemplary cause. And we should be given liberty so that we can file a FIR against the death manifesto.
For that you don't need liberty.
No, why liberty is necessary? Because 77 matter, and we have to explain why we delay. Why?
No, it's not a delay. This came to light only in the
Of course.
pendency of this case.
Writ petition. Of course, Mali, yes, we can do it. Lordship, two paragraphs says, one person says two things. It's the own statement. How can Lordship believe it? The front is, they thought it that typewriting is by a computer, it will be okay. They're making their date of birth 14 years. His age is 14 years. Actual age is 16 years. That has been clarified. And Lordship, two letters, regarding two letters, two letters has been clarified. Both this person, first affidavit reply filed by them. These two letters have been clarified.
Mr. Chotia, just a minute. Madam, in his service book, when he had entered the date of birth, it was done on the basis of which document? Let us see that certificate. That will clarify everything. Because Mr. Chotia, his contention is that the date of birth recorded in the service book is erroneous. 2 years more has been shown. Otherwise, he should have been 2 years younger. But that entry in the service book is on the basis of some document. Let us see that document. It has to be his document. Let us see what is the document.
There-
1/6.
This is your fact certificate. He shows there 14 years.
No, no, madam, this cannot be the basis of your entry in the service book. You said that you had entered the date of birth correctly in the certificate, in the service book, and therefore you had issued the retirement notice.
Yes.
Now that entry has to be on the basis of some document. This cannot be the document. If this is the document, you would not have said that his date of birth is 1960 instead of 1962. He claims that he was born in 1962.
He claims 62. Now, as per our record, he is 60.
60. Now, even in the service book, he was recorded to be date of birth of 1960.
60.
So it was on the basis of what? Which
What
document?
basis? Yeah, actually, madam.
That document will clarify everything. Will confirm the petitioner that this is your document. What happened to this document?
And lot of 2 letters he cited, my lord, issued by the board, the BC Medi. He is the my lord, unscrupulous officer. He is fighting for his after retirement. Lot of kindly see page 6 of his affidavit reply. That is clarified. 2 letters.
Page,
Page 6 of his affidavit reply.
running page,
Filed on my lord,
running page,
4/12/2020. Running page, my lord, I am
4/12.
2020. Annex A, page 6, internal page.
Affidavit in reply.
Yes. Annex A, page 6.
4/12. Yes, 4/12. We have got that
Oh.
as 35. What is there?
Dated is 5/8/2020 letter.
Page, internal page,
Page 11, page pilot 6.
internal page
Internal
11.
6.
Oh, just a minute, please.
Five eight 2020.
Internal page 6.
Yes, page 6. Type to be.
6. Yes, what is this?
Yes, that is issued by the Deputy Secretary Board to the Director of Health Service. Why is issued this letter, my lord? Because 2 letters, 19 October 2017, that was, my lord, inquired and Director of Health Service, we have informed by the board that his age is 16 years. And thereafter 2018, why he obtained this another letter from the unscrupulous officer, he reducing his age as 14 years. That's why, my lord, they become confused. 2 letters received. Who asked him to produce the letter in 2018? In 2017, we have clarified that his age is 16 years. Then, my lord, again, this letter has to be clarified, my lord. This lord, the Director of Health Service, we have written them. Madam, with reference to the letter cited that I am the director to inform you that the details of the clarification as requested by you in respect of the verification of a report of Samsul Haq Barbu, have hearing rule number so and so mentioned, exemption 77. Letter dated so and so, letter dated by 31/10/2017 and 5/4/2018. 2 letters issued by the unscrupulous officer. And paragraph 2, the actual date of birth of the Samsul Haq petitioner so and so is 77 is 16 years, 5 months, 90 days as on 1/3/1977. It is the correct as per record. In a letter dated 5/4/2018, the date of birth was type S, 14 years, 5 months, 90 days as on 1/3/1977 in place of 16 years, 5 months, 19 days as on 1/3/77 through oversight. That has been clarified. When we clarified, then his retirement notice was issued perhaps. That is that. One letter we have clarified, his age is 16 years. Why in the next year another letter is issued, obtained by him? Who directed him to issue? He obtained it, 1918. No, you reduced it. That's why these unscrupulous officers, my lord, he was faced with departmental proceeding also. This is clarified. All these things are clarified. This is a not genuine certificate. This is a fact certificate. And date of birth is, my lord, also fact, not 14 years, 16 years. That is correct. Our record is there. Our first affidavit, we have annexed the MRI. MRS copy is the mallet sent by the school authority at the time of the lordship knows about it. Then on the basis of that, we recorded our date of birth or age, whatever may be the candidate. This is the case. Now this factory should be mallet erected. But this factory should be mallet, the roots of the factory should be mallet. This should be mallet stop. In the social maintenance ballot is very difficult for all these things. How they are making it ballot? I am not getting it the first case ballot. Two other case I have got it from the Coimbatore district and Silchar. Particularly these two district ballot, they are doing like that. Who are them? And in recently in University Guwahati, what happened? Lot of ballot. What's the aware of it? The fact certificate, fact numbers, even in the name of re-evolution. That is why this maintenance should be ballot totally ballot.
My lord, my humble submission.
Okay,
is
we'll
that-
come to madam, anything? What is your stand?
That was cited as
So you have taken action as per the clarified letter.
That was the case, and another case, Hussain Ahmed Borbhuiyan case, that was pending for a long time. And it was also kept part heart mallet thereafter to release it mallet. We file additional affidavit as per direction of the Honorable Court, verifying the genuineness of the certificate produced by him.
Okay.
That's all, man.
Yes, Mr. Chaudhary.
My lord, my humble submission, my lord, reply will be given by my learned
No,
senior
we are
friend.
closing this. We are not waiting for reply. If you cannot give the reply now, we are not closing.
No, my
this.
lord. My humble submission is that if these two certificates, my lord, admit card and certificate are fake, my lord, as they claim, my lord, then where is the original, my lord? This was exactly questioned by the earlier Honorable Mr. Justice A.D. Chaudhary, my lord. Where is the original certificate issued by this two serial number? If assuming that these are fake, my lord, with a manufactured date, my lord, where the original certificate, my lord? Issued under this two serial number. There must be some certificates, my lord, issued under this two serial number, my lord.
Now, after getting the clarification from the SEBA, which had issued the certificate, where is the scope now?
Sorry, my lord.
After getting the clarification by your employer, your
No, my
employer is the health
Now
department.
they are saying that this certificate was manufactured by the petitioner, my lord.
We are not on the manufacturing aspect. SEBA had looked into the records,
Now
which is
question
the
my
authority
lord.
which had issued the certificates.
Now, my lord, tomorrow if suppose petitioner is asked about his date of birth, my lord, tomorrow, then what he will say, my lord? Because he will be go by his certificate, admit card or certificate, my lord. He cannot say no, as per my certificate, my date of birth is so and so, but SEBA did not recognize it.
We are not here to answer those questions.
No, my lord, for
Why are you putting those questions? Is it the issue before us? Don't raise irrelevant questions. What we'll do tomorrow is not our business. You do whatever you like.
sorry, my lord.
What is your take on the clarification letter 5/8/2020? 5/8/2020 issued by the SEBA that the letter of 2018-54 was issued by oversight, and your date of birth has been ascertained to be 16 years, 5 months, 19 days, as on 1/3/1977.
No, my lord, our case is that as per admit card as well as per certificate, my lord,
That we have noted. Okay,
our,
we'll conclude this. Third, NJ Dutta, the concept for the petitioner. Huh? Huh? No, NJ Dutta asile. Secretary, Pichichutia, Saber, the Bora, Standing Council, Health and Family Welfare Department. And madam, you're appearing for anybody?
my lord, my humble submission, my lord.
Madam, are you appearing for anybody? No. Yes.
My lord, since because of this issue, my lord, his pensionary benefit has not been granted, my lord, because that may be directed to release his pension as per the date of birth. Point to, my lord.
What action they will take, they up to them, my lord.
No, my lord, there is
Now, why have you withheld the pension?
because of this case, my lord.
Now, is there any bar in this? You pay the pension?
Yes.
Hearing is concluded. Judgment is reserved. Now, even if you take your date of birth, which you have ascertained after getting the clarification from SEBA, you have to pay the pension. That is, he's claiming to stay for 2 more years. We may accept, we may reject, but so far as your action is taken, pension is you have to pay.
Yes. And not my lord, if we are there, there is a dot. His factor where before that date, my lord, 27 June, 77 dot. In original, there is no dot. That was the secrecy, my lord. That's why we are keeping it, my lord. His fact certificate, page 16. That's enough, my lord.
No, you have pointed out the 77,
Yes, that is true.
7, the font is slightly different.
Yeah, and font is also the letter lordship Kalisi compared it. And our record also says first affidavit we have annexed it, my lord, MRS.
Do you have the service book, madam? Should have got the service book. What documents did he submit at the time of entry into the service?
Yes, my lord, that will,
That
yes.
would have cleansed the entire issue.
yes, my lord.
You take this back, originals.
My lord, he produced the original one that may be noted, my lord, because we'll take some help. Because he is produced before you, lord. Obliged, man.
Yes.
Obliged. Obliged.
Wait, Gujarat. My lord, a very short point is involved in this case. Is two petitioners. They were basically originally they were my lord diploma holder. So therefore they are recruited as junior engineer in the department. In the Panchayat and Rural Development Department.
They are junior engineers, diploma holders.
Originally, they were diploma holder and they entered the service as junior engineer in the Panchayat and Rural Development Department.
Hmm.
Now, subsequently, my lord, they acquired the degree of BTech or whatever is required for
B
recruitment.
degree.
BE degree. Now, as per the provisions of the extent rule, the moment a junior engineer acquires the degree, then in the next available vacancy, he is to be promoted. And once he is promoted, he will be treated as a direct recruit. He loses these earlier benchmark. He enters the cadre. Now, in this case, the petitioner became eligible in the year 2013. And the promotion was given that too after we approached this honorable court on this kind of an order, that too in 2019. Our only prayer is, my lord, our promotion should be anti-date. That's all. If your lordship would kindly come to the rule position at page 63.
63.
Yes. It starts at page 63.
Yes.
Yes. And the relevant rule is at page 66, rule 11, 4C.
What are the rules called?
Rule is, my lord,
Assam
Assam
Panchayat.
Panchayat and Rural Development Officers Technical Service Rule 2015. It has been amended subsequently, but then we are concerned with this unamended provision.
Okay.
And the relevant portion is at page 66, rule 11. Now, if your lordship will kindly come to clause C of sub-rule 4. Notwithstanding anything contained herein before in this rule, subject to suitability,
You are reading rule 11.
rule 11, my lord, sub-rule 4, clause C.
4C.
Yes,
Notwithstanding.
yes. Notwithstanding anything contained herein before in this rule, subject to suitability,
Hmm.
a junior engineer of Assam Panchayat and Rural Development Technical Service, on his acquiring the academic qualification as prescribed for a direct recruit assistant engineer, shall be promoted as assistant engineer in consultation with the commission as provided in Rule 12 against the next available vacancy in the cadre, and such promotion shall be treated as direct recruitment to the cadre of assistant engineer for the purpose of this. So in my humble submission, my lord, Rule 1411 4C has 3 parts. First, right accrues on acquiring qualification, that is BE, BTech, whatever it is. Then consideration in consultation with APSC,
Yes.
and Lord, in the next available vacancy, he is required to be promoted.
Yes.
Now, what had happened following this acquisition, at page 24, lordships will find
Yes.
this is a minutes of meeting of the selection committee,
24, you had said?
page 24, Miller, of the writ petition.
Yes. Minutes dated
Yes.
5/2.
Yes. No, 20th February, Miller. Page 24.
I think 5/2 minutes.
Yes, 5 to 14. Correct. I'm sorry. Now, please come to 2. The Deputy Secretary, PNRD Department initiated the discussion and informed the members that due to shortage of technical officers in technical department, such officers are not being deputed to PNRD department. As such, some post of assistant project officer technical in DRDS are lying vacant. Therefore, the department has decided to upgrade the senior most junior engineer of PNRD department to the rank of assistant engineer for posting them in so and so. In this connection, Finance Department has already issued NOC
Hmm.
for upgradation of 27 number of post of junior engineer to the rank of assistant engineer
Hmm.
in the Pensionary department. So department also cannot take the plea that vacancies are not available. Admittedly, on 5/2/14, as many as 27 posts were upgraded. So vacancies were available. So we were not promoted. Then, my lord, we approached his honorable court, and the honorable court's order is at page 29,
Yes.
and the operative portion is at page 32, para 5. Hence, direction is issued to
Same,
the
these two
page
petitioners,
32, my lord.
same petitioners,
Yes, same.
279, WPC 279.
Yes, 15/5/17 is the date of order.
But there are 2-3 petitions.
Yes. And the operative portion is at page 32, para 5. Hence, direction is issued to the state authorities to examine the petitioner's claim for promotion to the cadre of assistant engineer under Rule 1411C of the Panchayat Officers Rule. The authorities will verify whether petitioners have acquired the requisite qualification from the competent institution. Exercise in this regard is ordered to be completed expeditiously, preferably within a period of 6 months from today. So even if we construe, my lord, this order, which is of 15/5/17, within 6 months, that means by November of 17, it should have been done. Whereas we were promoted on 10/1/2020, that order, lordships, will get at page 41.
10/1/2020.
Yes, 20.
You said 2019 initially?
No, I'm sorry, my lord. It
10.
is 10/1/2020.
10/1.
Cabinet decision is of 29.
But the actual promotion is up for 10th of January.
Yes, my lord,
2020.
at page 41.
Page 41.
Yes.
41. Yes, please.
In the interest of public service and in compliance of the cabinet decision held on 21/10/2019 and on creation reorganization of the cadre post under Panchayat and Rural Development Department, and in compliance of the order of the Honorable High Court dated 15/5/17 passed in WPC number 279 of 2015 in the matter of Dhiren Borali and another versus State of Assam, and for avoiding contempt proceeding drawn in contempt case number so and so, and as per provisions of the Assam Panchayat and Rural Development Officers Technical Service Rule 2015, and subject to reversion without assigning any reason thereof, the Governor of Assam is pleased to promote the undermentioned junior engineer having degree in civil engineering from institution recognized by competent authorities to the post of civil engineering from his authorities to the post of assistant engineer as direct recruits in the scale of so and so, plus other allowances as admissible under the rule, with the date of taking over charge of the offices as shown against their names below. Now, serial number 7 and serial number 11 are the two petitions.
Dhiren Bharali and Jyotish Das.
Yes. Now, my lord, our case is to implement an High Court's order, cabinet decision is not required. Posts were available. The mandate of the rule is very clear that on the next available vacancy, and vacancies were there and posts were also there. Therefore, my lord, there is no question of, promoting us in the year 2019. That is our case. Initially, there was some doubt regarding the degree from where we acquired it, my lord. That doubt was also cleared. So the admitted position is, my lord, we became eligible in 2013. We were promoted in 2020.
At least from 2017, you issued.
Exactly within 6 months. So going by there, so therefore my humble submission is, my lord, It's a fit case where lordship will direct the
These
authority.
rules are,
to-
I think, perimeter with the PWD rules.
All rules, same.
Same rules, same.
Even the rule has been amended.
Okay.
Now, amended rule, the adverbatim, my lord, the position is same.
78 rules of PWD, I think, same language.
Same.
On the next
And all
available,
works
next available
department.
vacancy.
Yes. So that is my case, madam.
Your acquiring of B is not doubted.
Not in dispute. The fact that they have promoted us, my lord, there is no dispute.
Mr. Dutta.
Uh, I want to read the page 32 again, my lord, the order, my lord. Lordship may kindly come to the page 32 of the petition once again, my lord.
Yes.
Paragraph 3, I am reading from the rules, my lord. Para 30.
32 paragraph.
The rule, my lord, paragraph 3, there is a rule.
Hmm.
Rule 11(4)(c),
Yes.
notwithstanding anything contained herein before in this rule, subject to suitability,
Yes.
a junior engineer of the Assam Panchayat and Rural Development Officer Technical Service on his acquiring the academic qualification as prescribed for the direct recruit assistant engineer shall be promoted as assistant engineer in consultation with the commission as provided in Rule 12 against the next available vacancy in the cadre, and such promotion shall be treated as direct recruitment to the cadre of assistant engineer for the purpose of this rule. That means, my lord, the eligibility will not directly accrue their right, my lord. Only on the next promotion, they will get the promotion, my lord. Not the instantly on the getting the eligibility, my lord. They will not eligible for promotion. In the next, my lord, the language is, my lord, that in the next available vacancy. Now, lordship may kindly paragraph 5 once again I'm reading.
Yes.
Hence, direction is issued to the state authority to examine the petitioner's claim for promotion to the cadre of assistant engineer under Rule 11(4)(c) of the Panchayat officers rules. The authorities will verify whether the petitioners have acquired the requisite qualification from the competent institutions. The exercise in this regard is ordered to be completed expeditiously and preferably within a period of 6 months from today. That is admitted. It is ordered accordingly. However, this order should not be disturb the private respondent. In that case, my lord, private respondents were there who were directly recruited, my lord. Who were directly recruited as assistant engineers in the Pensionary department. Now, lordship may kindly come to my affidavit in opposition, my lord. We have filed page number 87, para 5. Filed on 31/8/2022. This is the explanation why delay was there, my lord.
Page.
Page 87, para 5 starts, my lord. But I'm reading for the page 88, my lord. I'm reading from page 88.
Yes.
May I read, my lord? It may be mentioned that the petitioners via letter dated 22/5/2017 submitted a copy of the Honorable High Court order dated 15/5/2017 in WPNC so and so, wherein direction had been issued to the state authorities to verify whether the petitioners had acquired the requisite qualification from the competent institutions and to examine the petitioner's claim for promotion to the cadre of assistant engineer under Rule 11(4)(c) of the Assam Panchayat and Rural Development Officers Technical Service Rules, so and so, preferably within 6 months. Accordingly, the department-wide letter number PRD so and so dated 17/6/17 requested the petition number 1 and 2 for submission of their respective certificate of degree in civil engineering or its equivalent to the department for verification and necessary action. On receipt of the requisite educational certificate from the petition number 1 and 2, by letter dated 29/6/17 and 27/6/17, the same were forwarded to the Joint Secretary to the Government of Assam, Higher Education Technical Department, by letter dated so and so dated 4/8/17 for verification and authentication from their end. Due to the non-receipt of the required verification authentication report of the certificates submitted by the petition number 1 and 2 from the Higher Education Technical Department, 4 reminders letter had been issued by dated 5/3/18, 25/1/19, 9/7/19 and 14/8/19, my lord.
Yes.
Thereafter, my lord, the report was received from the Higher Education Technical Department by letter dated 30/8/2019. Besides the petitioners, another 25 junior engineers of the department also submitted certificates of degree in civil engineering issued from the same institution, that is the Institution of Civil Engineering in Ludhiana, Punjab, to get the benefit of the promotion to the post of assistant engineer. The submissions of the certificate issued from the same institute by 27 JEs also raised doubt, and the department decided to verify the authenticity of the certificates, my lord. That was direction by the honorable court, my lord. Accordingly, the certificates were sent to the controller of the examination institute of so and so Ludhiana, Punjab for verification by letter dated 6/12/2019, and the verification report was received on 30/12/2019. That is important, my lord. 30/12/2019, and thereafter immediately on 10/1/2020 they were promoted to the assistant engineer, and the next year 26 to 2021, my lord, assistant executive engineer. Now they are working as a assistant executive engineer, my lord. Therefore, the delay was not for our department's fault, my lord. The order was from this honorable court was to verify whether they are eligible or not. And to verify, my lord, we have taken the steps, my lord. Now the issue before before this court is, my lord, that whether they are eligible for national benefits or not, my lord. Only their case is that they want national benefits, but there is nothing, my lord, that we are because of our fault, my lord, that was delayed. And not only this petitioner, my lord, there are other 25 junior engineers, my lord. We have together we have taken, my lord. Thereafter we have promoted, my lord. No bona fide, no mala fide or nothing, my lord, in for our department. That is my submission.
No, first, Mr. Datta, I have to answer two questions. Suppose there was no order of this court. Weren't you under an obligation to consider their cases if you doubt their qualification regarding the institute from where they had acquired the degree? Then you make make an inquiry. But where is your consideration? See, the rules does not say that promote them. Rules say that consider them as per suitability.
My lord.
What is required is you have to consider them. Bring them into the zone of consideration, consider them, and you pass appropriate orders whether they can be promoted or not.
My lord.
But can you postpone your consideration?
That explanation.
And number two, whether the consideration is only dependent on an order of this court.
My lord, that explanation I have in para 9, my lord.
Yes, what you stated?
Page 91, para 9, maybe.
Yes, yes.
Third line I'm reading, my lord. The Departmental Selection Board for upgradation of junior engineer to the post of assistant engineer under the Panchayat and Rural Development Department in its meeting held on 5/2/2014, my lord, it decided to prepare the list of JEs to be upgraded to the rank of assistant engineer on the basis of the provisions of service rule of public deed and PWD rules, my lord, and in strict maintenance of roster as per OM of WPT and BC department. However, this post could not be filled up in time due to number of court cases pending, my lord. WPC 206512, 403914, contempt case 6214 against the selection process, including an interim order passed by this Honorable High Court in WPC 972/2014 in the matter of Sri Broja Kumar Deka and others versus State of Assam, my lord. In the case of WPC 972/14, the Honorable High Court had disposed of the writ petition by order dated 18/9/2014 with a direction that the Departmental Selection Committee may be proceeded with the selection for promotion of JEs filling up 29 posts of AEs and consequential placements of deputation as so and so in the DRDS by following the criteria already determined, that is merit with due weightage to seniority, without taking any recourse to the Reservation Act so and so so and so. Accordingly, the department had collected ACRs in respect of junior engineers serving under the Panchayat and Rural Development and so department was requested to furnish views, comments on the matter of maintenance of roster in connection with the promotion upgradation of junior engineer. The second meeting of the selection board was held on 11/11/14, where it was decided to wait for completion of the departmental service rules for technical officers and to seek views, comments from the personnel department in terms of adopting the Assam PWD department service rule for filling up the upgradation post of assistant engineers. Accordingly, the matter was referred to the personnel department for their views as per the decision of selection board. However, the personnel department returned the relevant file by their endorsement dated 9/1/15 and advised to reapproach personnel department along with the draft service rule. The draft service rules was again submitted to the personnel department, and later on the service rule was adopted by notification dated 30/1/2016. My lord. That is why, my lord, some delays were there initially, my lord. And thereafter, my lord,
The second question is that, see, ultimately you had done some exercise and you have promoted them on 10th of January 2020.
yes, my lord.
You have recognized that they are suitable for promotion.
Yes.
And their suitability did not arise in 2020.
Yes, my lord.
You have made the promotion in 2020. Suitability would arise from the date they had acquired the B degree.
My lord.
That was in the year 2013.
My lord.
Now, the delay is because of various grounds. You may have genuine grounds. But after ultimately promoting them, aren't you required to give the effect, at least the notional benefits?
My lord, the rule is saying, my lord, in the next vacancy, we have to promote. And
Which you did
the
not.
first round of the litigation, my lord.
Well,
in the
no,
first-
which you did not. You had reasons.
Yes, that was missed.
You had reasons that some
Yes.
cases were pending.
My lord.
But rules, and we suggest that next available vacancy, at least you have to consider subject to the suitability.
Suitability.
There was no consideration.
Yes, my
The
lord.
consideration of the
That was
ultimate,
admitted, my lord. That was
consideration
admitted.
ultimately in 2019, promoted in 2020 January. Now,
As per
once,
the court's direction, my lord. In the first round of litigation, my lord, the honorable court directed and they have admitted that, accepted, my lord, that after verification, we will promote them. And this is not a case, my lord, that their juniors were promoted before them in the same footing, my lord. All those same footed persons were promoted together, my lord. Earlier, the promotion was made only for the direct recruitment, my lord. And the same footed persons were promoted together, my lord. It's not a case of the petitioner that their juniors were promoted earlier.
now from 2013 till 2020, their appointment, did you make direct recruitment to the post of assistant engineer?
I don't think so, my lord. I have to take instruction on that
That will
point.
be very relevant.
Yes, my lord. I have to take
Because
instruction on
they have to be treated at par.
my lord.
Once a person who is in service,
Yes,
he
yes.
acquires the degree,
My lord, my lord.
and he has to be treated at par with a direct recruitee.
My lord.
And his promotion would be treated as a direct recruitment.
My lord.
No, my lord, I have instructions to submit. There was no direct recruitment period then, no?
Not even.
Until night.
Not promoted. Direct.
No direct recruitment.
So it's not a case, my lord, that juniors were promoted earlier.
But Mr. Chaudhary, what
My
is your,
lord,
what
my
is
lord,
your-
as your lordship has very rightly pointed out, right to be considered for promotion is a right. Now, it is not the department's case
that
that
considered?
vacancy was not available. Therefore, we could not consider it. My lord, the alibi, the litigation of 2014, orders were of 2014 and 15. Kindly similar 18/9/14. In case of WPC 972/14, Honorable Guwahati High Court had disposed of the writ petition by order dated 18/9/14 with a direction that department, etc., etc. So, my lord, the writ petition itself were disposed of in 2014. Had it been a case, next available vacancy is not there, then things would have been otherwise. Then my cause of action would not have fructified. Now, in the absence of that plea, my lord, these are all, my lord, alibi. How can we take a judicial notice of, my lord?
The cases are of which year?
And my lord, these cases are of
20.
disposal is of 18/9/14.
18 and 14?
Yes. And this contempt case is filed by us, me, the petitioner. This WPC, my lord, 972/14 was disposed of 18/9/14. And my lord, evidently after the cabinet decision was taken, they have promoted us. That's why I said, whether to implement a high court's order, my lord, a cabinet decision is required.
No, we can go to the extent of not even the High Court's order, whether to follow the law.
Exactly.
That is the
The
law.
mandate is the moment next available vacancy, my right, my consideration follows, should have followed. They have not extended me the consideration. So therefore, my lord, I don't think there is any escape for them. Well, my learned friend has tried to justify the action, but these are neither here nor there. And the most crucial thing is whether vacancies are available. We say there are, they have not denied. Neither they have disputed that. On the contrary, they say some litigations are going on. And my lord, our conflict is not with any direct recruit. Our conflict is not anybody else. We have a right, whether that right has been, we have come for enforcement of that right. The right is that in the next available vacancy, our case should be considered. They have not done it. That is the only case. Not that, my lord, we will be asking for any monetary relief. At least our notional benefits should be extended.
What kind of notional benefits?
My lord,
You have been,
our entry in the cadre of assistant engineers should be reckoned from that date.
no, you have, what has the standing council has said, you have in the meantime been further promoted.
Further, yes.
So,
Further promoted to the grade of assistant executive.
now how, suppose we grant,
No, my lord, the consequences will follow. All consequences will follow. If my promotion to the cadre of assistant engineer is predated, then my lord, all consequences will follow.
fitment, everything.
Yes.
Okay. Okay, we'll consider.
Deeply.
Yes.
May I submit only 2 points, my lord?
Yes,
Only
yes.
2 points. First, my lord, the first litigation, my lord, the order dated, my lord, 15/5/2017, that may be considered, my lord. Because, my
Yes,
lord,
yes.
as per this honorable direction, we have acted, my lord. And the second thing, my lord, the issue that, my lord, that whether the eligibility and the date of promotion, which will be the correct point, my lord, the correct date, my lord. Whether they are eligible for any national, that may be considered.
My lord, if my right has merged with the order of the Honorable High Court, then my lord, by November 2017, I should have been given. Because the order is of May, 6 months. If we take that view also, my lord, that my right has merged with the order of the High Court, then at least from November 9, 2017, my lord.
Mr. Datta, there is one more thing.
My lord.
You made an exercise for verification after the court's order.
Right.
Did you make any such exercise prior to the court's order
No.
regarding the verification of the degrees which were somehow doubted in the initial stage? You took
don't-
2 years. You said you had good reasons. Okay, good reasons. But you started acting only after the court's order.
Yes, that is admitted, my lord.
Okay. Civil court. Again, Chaudhary, step by Sri
Deep
Sri
level.
Goswami. Anything, Mr. You're for finance department.
I'm for the finance department, respondent number 4.
Oh,
Only one of when the petitioners became eligible for being considered for promotion, my lord, at the most, my lord, they will get the notional benefits.
No, they are asking for notional only.
Yes.
And even we can also think about from the date of the court's order,
Yes.
within the date, 6 months.
So therefore, my lord, when the right accrued to them, my lord, from that.
Right of consideration was there, immediately
In
they
the
had acquired
2013
the,
itself.
you consider them and you can hold them to be unsuitable, that's a different matter. You consider, hold them to be unsuitable, we have nothing to say. It may be a matter of examination, but you have not done that exercise. Okay.
Obliged.
Deeply.
Okay, okay. We'll try to pronounce as soon as possible. AG, SQMAD.
Obliged.
Yes.
Subject matter relates to regulation of service of workers employees. Your Lordship, petitioners are appointed as workers employee in PHC in the year 1988. Lordship. Thereafter, in the year 1990, Lordship, they were deputed to Assam Urban Water Supply and Sewage Board,
1990,
Lordship.
deputed when?
1919, 1/4/1990, Lordship. Thereafter, as per the cabinet decision, Lordship, they were reverted back in 2011, Lordship, to PHC,
2011.
2011. And Lordship, during their deputation in Assam Urban Water Supply Sewage Board, Lordship, they were regularized, they were upgraded, Lordship.
Yes.
And thereafter,
Upgraded as?
upgraded as the regular Khalasi and peon, Lordship. Thereafter, in 2011, they were reverted back to Lordship to THC, and there was one recommendation was made that they will be their regulation would be considered at the earliest. After that, Lordship, they have not their regulation has not been considered, and in 2022, Lordship, an order has been passed by the authorities that as per the Upendra's case, regulation cannot be considered. Now, also, I kind of see appointment order, Lordship. Case 19, Annexure A.
Mr. Have a seat, we'll come to you. Have a seat. Yes, page
Page 19, Lordship, Annexure A.
19.
19. Okay, this is by the Public Health Executive Engineer, Topri Division. Okay, subject to termination without notice and without assigning any reason thereof, and satisfactory service police verification report. Joiner and Sharma working as master role under Tupri PhD Division 2 is hereby temporarily appointed as the WS Khalasi cum Chowkidar in the scale of they were given the scale of velocity in the initial.
But where is the scope of consideration for regularization after open DAS?
Lastly, after their case is different, lastly, because they were deputed, their initial appointments were at works as employees, lastly, but they were deputed in Assam.
How does it make any difference?
Lastly, deputation is and in the
Whether you are deputed or not, whether upgraded or not, you have to meet the
But yeah,
requirements.
when they were reverted to the PHC lordship from storage board, which post lordship they were reverted. Lordship, may kindly see the page 27.
Now, how do you expect an order of regularization after open DAS? You tell us.
All the employees who were reverted from the serious board lordship, they were regularized. Only these two employees, 3 employees lordship, there is another case.
Can there be a direction, mandamus? If
Look.
the authorities on their own volition they do, they can do. But can we pass a mandamus?
Lordship,
When the division
their
bench
service-
has authoritatively said that there is no question of
They
regularization,
are protected by lordship para 53 of the Umaripi case.
where
lordship.
where is the initial appointment under a vacant and sanctioned post? Show us your initial appointment as master role.
But in the serious board lordship, they were regularized.
That is
And
not, they were not regularized, madam, they were upgraded.
Lordship. But yeah, lordship,
Show us the three, you fulfill the 3 conditions of paragraph 53 of Uma Devi 3. You were appointed in a sanctioned vacant post.
it was
You
not
have
taken.
the qualification and you are not protected by any court's order for a long continuation. First condition you do not fulfill.
Lordship, they were workers employees, not against any sanction post.
So
This
how
this
if you
one-
do not meet Uma Devi, how can you direct?
And there is no lordship, they were not continued.
You
under
cannot
strength of
best
any
be
court order.
treated as at par with Upendas.
Even after the Lordship opened the case, some employees have been regularized in PHC.
Madam, we are not repeating. If they do it on their own, we have nothing to say. It's their own prerogative. How do you treat? But if it goes as a mandamus from the court, we have to go as per law. There is no scope.
The Lordship may kindly see the page 27.
2-7.
27.
Yes, please.
Also, this is by the additional chief engineer, Lordship. This is the notification in pursuant of to the approval of the Honorable Cabinet Government of Assam that is so and so. The Office of this Board of so and so for reversion of employees along with posts to PHC department. The department has placed their services against different offices as detailed in Annexure 1. Here, Lordship, at page 29. Petitioner's name is at page 29. Serial number 4344. W.S. Khalasi, Office of the Executive Engineer, Corpeta.
Page 29.
Page 29, Lordship, serial number 4344. Horidas and Jonaran Sharma.
Yes. What do you want to show here?
The Office of the Executive Corpeta and Nalbari, they were, after reversion, they were engaged, Lordship, attached with executive in the Office of Executive Engineer, Corpeta and Nalbari. Thereafter, Lordship, 30. This is by the Managing Director, Assam Urban Water Supply Storage Board. With reference to the above, I would like to submit here with the present status of the PHC, WS, and MR employees already reverted as per Annexure 1 for favor of your necessary action. So here now page 31, Lordship. Page 31, serial number 5. Jonaran Sharma, Workers Khalasi, date of appointment. Lordship.
Number? Serial number?
Serial number 5.
Page P1.
31.
P1. Petition number 1.
Yes, Lord.
Joiner is petition number 1.
Petitioner number 1.
And this petition number 2, where?
2 is 9, Lordship.
Horidas.
Horidas. Here's Joinaran Sharma, Workers Khalasi, joining date in PHC, Lordship 33-1988. Date of joining in today's board, 1/4/1990. Name of original post in which they join in PHC and Assam Today's Board, it is W.S. Khalasi, present status and date of promotion, Lordship. Pion 1/2/2060. And in case of Horidas, Lordship, serial number 9, date of promotion, Khalasi on 2/9/2006. Also, it is also 2006. Now, Lordship, in case of workers employees, Lordship, there is no question of promoting them to higher post, Lordship. Only in substantive post, Lordship, promotion or deputation is affected. Here they were deputed, they were promoted, and which the promoted post, Lordship, they were reverted back which promoted post. So therefore, the nature of their service is different from the other workers employees. They were promoted. Promotion is not, Lordship, promotion criteria is not applicable in regular workers employees. They were promoted here. And their reversion.
How the Surveillance Board has treated you, we do not know.
Lordship.
You are under a particular board while you are being promoted.
And when they were reverted, we promoted the post which, where they were promoted, Lordship.
That,
And it is also
that process of promotion, we do not know how the board had promoted. They must have done it. But will you overcome the requirements of Uma Devi 53?
Page 32. This
32.
is also the PHC letter, Lordship, order.
Yes.
This is Lordship by the additional chief engineer. In continuation regarding reversion of staff from Assam Urban Water Supply Storage Board modification thereof. In continuation to the above, it is stated that the managing director Assam Water Supply informed by this letter so that some of the reverted employees, were promoted, placed with higher responsibility during their tenure in Assam Urban Supply and Storage Board. As the posts held were shown in the notification as per earlier communication from Assam Board, now there may please be read as follows: controls for WS and MR concerned to your office only and from the date of their joining. all the other conditions remain same. Proposal for their regulation and retention, etc. may kindly be submitted at its earliest. After that, lawsuit 2011, it is corrected lawsuit as per the promoted post. They were again engaged in the PHC lawsuit in a reverted post. After that, though it is stated that their regulation will be considered at the earliest, it is not considered by the authorities. And earlier lawsuit, though it was not recorded in the order lawsuit, Honorable Court has directed the PHC lawsuit to clarify whether their names were lawsuit forwarded for regulation or not. Because all other employees reverted from Assam Survey Board lawsuit, they all were regularized, except these two employees and one Horizon the Haloi lawsuit. His case was also, it is an honorable court lawsuit, it is already disposed of. This case was regularized lawsuit. They have made some objection in this case. So only these three employees remain lawsuit. And page 35, this is the order of this honorable court. On the basis of this order lawsuit, they have already. Page 35.
Yes.
The same service condition, everything is same lawsuit. Operative portion is page 36, last para lawsuit. And here lawsuit PhD department has admitted that page 36, the third para lawsuit. At this stage, Mr. P.N. Goswami, Learned Standing Counsel, PhD department submits that the case of the petitioners were placed before the concerned secretary of the department. However, as there were insufficient materials, the same has been returned back to the respondent number 2 for resubmission of the case of the petitioners. He submits that the respondent number 2 is taking active steps for placing the case of the petitioners before the respondent number 1 with all relevant materials so that the case of the petitioners can be considered at the earlier date. Accordingly, this petition was allowed and these petitioners were engaged, lawsuit regularized page 38. Page 38 is the order. But in our case, lordship, they could not place before this honorable court whether our names were placed before the authorities for consideration for regulation or not. Otherwise, lordship, these petitioners were entitled for regulation in 1993 itself because they were appointed before 1993 as per the policy decision of the government. In 2006 also, the government has taken a policy decision to regularize lordship remaining workers and masteral employees, and in that case also, lordship, they have not considered our case. Even after that, when the similarly situated lordship workers employees were considered in 2020, it is this regulation order is of 2019 lordship. Then also our case was not considered. Now, lordship, the finance department has submitted their affidavit where they have stated that they have no knowledge whether the petitioner's name was placed before the authorities for.
But this order at page 38 is not connected with the court case you have mentioned at page 34, madam.
Okay.
You have said it is connected. Page 38 regulation order is of another case.
Lordship, these are they were the petitioners in this.
Sorry, that is not the petitioner. This is in see the petitioners, Ratul Bora, Ashot Haloi, Nandopani Pradhan. Here the petitioners were Surendas. Where is Surendas?
These three were dear lordship surrenders. I have no information, lordship.
And where is the reference to this order of 23/3/2017? See, this writ petition is different.
Honorable High Court contempt case in WBC number
6532. This is not 6532. This is a different case. It's 3476.
Yes, sir.
And this is of 2011 case.
2016 case, lordship.
It was 2011 case decided on 2012.
But regularized in 2019 law.
Doesn't matter. We do not know what was the order, what was the contempt matter.
Confusion. But these petitioners were also the parties in this petition lawsuit. Now, lawsuit, as per the finance department also lawsuit, as per the affidavit of the finance department, they have no knowledge whether the PHC has at any time has placed the petitioner's case before the authorities for regulation. Lawsuit. This is by the finance department affidavit. By respondent number 2. Paragraph number 5, page 46. Page 46, paragraph 5. That the finance department, as per a decision of the cabinet dated 22/7/2005, by data dated 22/8/2005, granted approval for regulation of services of 5,892 workers and 25,069 masteral workers of different government departments engaged prior to 1/4/1993 and in continuous service without break since their engagement by creating posts created specifically for the purpose of regulation. However, it is not known whether the PHC department submitted proposal for regulation in respect of the petitioners during that period of 2005. It is first they were entitled lawsuit in 1993 as per the policy decision.
But
They
this,
were not
this
considered.
finance department stand is of 2005.
The 2005 lawsuit. Then also they have not considered in our case lawsuit in 2012 because
In 2005, they had said that they had regularized 5,000 numbers of
we were in
workers and 25,000. That time, neither Uma Devi was there nor Upendas was there.
maybe lawsuit, but at that time also we were
No,
eligible
after
for
Uma Devi
regulation.
and Upendas, as on
It is
today.
it is their left lawsuit. It is not our fault that our regulation was not got till date.
So now the law has come. Where can we direct something which is against the law?
But because the nature of their services, they are something different from the other workers or masteral workers because they were paid regular scale of pay lawsuit, increments, allowance, everything lawsuit. Even the
We have
efficiency.
seen many cases where scale payments are been made, even to workers employees.
And workers employees, that is the question lawsuit. And workers employees, though they were a workers employees lawsuit, they were promoted to the higher post lawsuit. And their reversion is also with
Promoted to what?
promotion.
What higher post? Kharasi and peon. Where is the promotion?
It is reflected as promotion lawsuit.
But what post? How can you be promoted?
It is their documents.
You're Khalasi, you're Khalasi, you're peon, you're peon.
It is their documents lawsuit that it is.
No, it is for you to say that I was in this lower post, then I've been promoted to this higher post. Both the posts are Khalasi, both the posts are peon.
And in they were holding the post lawsuit. Therefore, the nature of their engagement is not similar with the other workers.
You tell us, how do you overcome 53 of Uma Devi 3? You tell us that.
Plus, if their promoted post is held to be the substantive one lawsuit, in that case, they are
Substantive
protected
one,
discrepancy.
how are you promoted in the substantive basis? Was any the EPC held? How are you promoted? Have you
Lawsuit-
pleaded anything that the board had constituted a duly a board committee to consider?
It is the lordship, it is the cabinet decision to they put them or to revert them lordship. It is a high level
No,
committee.
no,
has-
regarding your promotion, how was it made by the Suarez board? See, you got some benefit, we have nothing to say about the benefit. If the department on its own gives benefit, it is okay. But from the court, how can it go as a direction?
Only lordship, these two employees were left out lordship, except all other employees have been till 2019, they were regularized. Even this lordship Upenda's case and after the Madivi case, everything lordship.
Where? Show us one incident.
This lordship,
Where?
this 2019,
2019?
the 2019 order lordship is 30, Case 38 lordship. This is
38.
2019, the 27/9/2019. This will
Yes.
be
In terms of what? In terms of an order passed in 2012. In terms of an order passed in 2012, Upendas was not there.
Yes, Lordship, Upendas was not there. Honorable Court has passed the order in 2012, but they were regularized in 2019 after the passing of the Upendas case in 2012. It was passed on Upendas case was passed on 8/6/2017.
Yes.
After passing of the Upendas case, Lordship, they have not stated that after Upendas case.
So what will happen to the order passed earlier? That has to be complied with. This order is of 2012. You don't even have the copy of the order.
In that case, Lordship, there is also departmental order to regularize their service at the earliest by order that is 2011, Lordship. They have not.
Madam, we have said that
accepted this,
if they do it on their own, we have nothing to say.
Lordship.
If they consider and regularize as you on their own, we have nothing to say. It's good
But
for you.
Lordship, it was their level, completely
But
their
can
level,
we
Lordship.
direct for regularization? Can a court direct?
And also, Lordship, in the meantime, they have, during the pendency of this petition, they retired, Lordship. So the action may be issued to regularize.
Both of them have
Both of
retired.
them retired.
So what is
Lordship.
there?
If they were granted lordship, notional regulation and some pension and other benefits are paid lordship, otherwise for more than 30 years, they have worked in the PhD department lordship as per with the regular employees. And they were holding the post as per this order lordship. So they are entitled to the protection of 63 of the open lordship Umadivi case.
50, if you are entitled to 53, show us your initial appointment that is against a,
As the workers employee.
was it under a vacant and sanctioned post?
No, there is no sanction.
Then how do you make, how
But
can you make
since
this submission?
Since thereafter lordship, they were lordship upgraded in the
Yes,
regular post lordship.
Mr. Kothakur?
We have pointed out because of the embargo placed by the Penda's judgment, it is categorically held that no work card employees can be regularized. And those orders of sewerage board lordship, which the petitioner is relying, their lordship, you will see there is a lot of fiction in those documents. At the bottom, it is also written, these are purely temporary. And lordship, those orders lack government approval.
Page?
For example, at page 38, this order that is being relied,
38.
38 lordship. At the very end, after the table, lordship can see the regularization is purely on temporary basis and may be reverted without assigning any reason. And this is done by an executive engineer, lordship, who does not have would not have a government approval to grant an order like this.
No, there is a mention of a government letter in the first line. in persons to government letter dated so and so 19/1/2016. May I have your seat, madam? Yes, what else?
And Lordship, the finance department affidavit also, Lordship, towards the end also says that because of the operation of Upenda's judgment, further regularization cannot take place anymore.
Page?
At page
Okay.
46, Lordship, of the finance department's affidavit.
Okay. Anything else?
And Lordship, in Upenda's judgment, which we have annexed in our affidavit, Lordship,
Page?
uh, at page 74, Lordship. At para 16, Lordship can see that, if I may read,
Paragraph?
16, Lordship,
Page 74.
page 70.
Para 16.
Here, Lordship, it would show that the observation is very general, talks about all work charge employees.
Hmm.
And finally, Lordship, para 23, the concluding part of the judgment.
Yes. Here in paragraph 16, 53 has been quoted.
53, quoted,
53 of Umar Devi 3 has been quoted.
and it says we shall examine whether work charge employees engaged prior to 93 can be considered. And the answer to this is in para 23. Lord.
Three. Okay. Anything else?
That is
Finance department is respond number?
Respondent number 2, my lord.
Yes.
Lordship may kindly see the initial appointment. Lordship may kindly see the initial appointment letter of the petitioner at page 19 of the writ petition. My lord, it goes to say, my lord,
Are you having some electronic equipment near the microphone? Okay, page 19.
page 19 of the writ petition, my lord.
Yes.
This page 19 order would go to show inevitably, my lord, that the petitioner was not,
Just a minute, please.
my lord.
One nine.
19, annexure A to the writ petition.
29-3 to 88.
Absolutely, my lord. So this order would go to show, my lord, that the petitioner was not engaged against any sanctioned vacant post. And this appointment letter was engaged by the executive engineer, not by the government. This order also goes to show that, my lord, his engagement was not approved by the government at that point of time. There was no approval. So, in his official capacity, the executive engineer PhD has engaged the petitioner. Now, petitioner continued in service. There were several correspondences. Lordship may kindly come, my lord, to page 27 of the writ petition, annexure E, which has been heavily harped upon by the petitioner.
Annexure?
Annexure E, page 27.
Yes, please.
This is with regard to, my lord, reversion of the employees, which the petitioner's counsel has heavily harped upon. Now, annexure, my lord, E, page 27 continues, my lord. It runs to several pages.
Hmm.
Relevant portion, lordship will find at page 29.
29.
29, my lord, where the name of the petitioners have been mentioned.
Hmm. Yes.
Page 29, my lord, on the left-hand column, lordship will find a serial number at 43 and 44.
Yes.
Haridas and Joynaran Sharma. There is one another person, Sri Harisaran Haloi. Now, against these three persons,
Hmm. Horidas is number 1, C1.
P1 is, my lord, Joynaran Sharma,
Okay.
P2 is Haridas here,
P2.
P2.
Harisharan is also there. Yes.
Harisaran are also there.
Hmm.
Now, these three persons are categorized in one block. So
Yes,
they will find
yes.
it in a tabular form.
Yes, yes.
Then
yes.
on the extreme right-hand side, lordship will kindly see,
Hmm.
my lord, there with regard information with regard to creation of post,
Yes.
that is absolutely, my lord, silent. Rather, in against, my lord, some other persons, lordship will see on the right-hand column, against some other persons, there is a mention of creation of post. Now, my argument is, my lord, that the petitioner, even as on 6/4/2011, on the date of issue of this notification, the petitioner has not continued to work in against any sanctioned vacant post. Even up to 2011, their own writ petition goes to show, my lord. Materials annexed to the writ petition.
Okay.
And, my lord, the dictum of this honorable court by coordinate bench, which lordship will find, my lord, at page, it runs from page 35, relevant
3-5.
35. My lord, the one similar order which the petitioner said to,
Yes, yes.
my lord, they submit that this is a similar order. Even that order, lordship will see, my lord, at page 36, the last paragraph. May I read it, my lord?
Please.
Page 36, last paragraph. On considerations of the submissions made by the learned standing council PhD, this court is of the considered opinion that this writ petition need not be kept pending. Accordingly, this writ petition is disposed of with a direction to the respondent number 1 and 2 to consider the case of the petitioners as has been done in case of Mr. Sharma, who was regularized by order dated so and so. The respondent shall complete the process as early as possible. So it is not a mandamus per se. Court only said that you consider, you have regularized somebody, you consider if that person can be accommodated. So this cannot be termed, my lord, with all respect, my lord, that this is a mandamus per se. Then
What is the date of Upendas?
Upendas, my lord, it is 8/6/2017. 8/6/2017.
This was before prior to Upendas,
This is prior to Upendas.
23/3/17.
Yes. Then lordship will kindly see, my lord, page 38. One similar order, which my lord, of course, the petitioners submit that it is a similar where some persons have been regularized. My lord
Yes.
will kindly see the tenor of the language, my lord, incorporated in this order. In pursuance of government letter to the Sabha and the honorable, so some contempt case was filed, my lord. Probably, my lord, in order to escape contempt, my lord, this order came to be issued. Now, here, lordship will kindly see who has issued this order down below. The executive engineer PhD. And this regularization is purely temporary basis and may be reverted without assigning any reasons. This order is not approved by the government. This order has been passed by the executive engineer PhD, Guwahati Division number 2, in his own official capacity. Nowhere it is stated, my lord, that the government or for that purpose, my lord, the finance department has accorded approval, because regularization will have to be against a sanction post. A post has to be created. How the post has been created, where, my lord, he will be accommodated, nothing of that sort, my lord, has been mentioned in this order.
Right.
Now, lordship, my lord, I will draw my lord's attention to the affidavit filed by the finance department. Lordship may kindly see, my lord. Lordship may kindly come to running page number 45. That is a part of the affidavit filed by the finance department. Running page number 45.
Tekendra Molla Basumotari.
Absolutely, my lord. Running page 45, I will, my lord, take the gracious indulgence of this honorable court to read only 3 paragraphs. Paragraphs 4, 5, and 6 of this affidavit. That will clear the whole issue.
Yes.
Paragraph 4. Deponent with regard to statements beg to state that as regards the order on February 21 as issued by the undersecretary, it may be stated that THC department by file number so and so submitted proposal and PHC department endorsement dated 7/1/21 was informed that as per Honorable Guwahati High Court order dated 8/6/2001 in so and so Upendas, master roll workers, casual workers are not entitled for regularization of their services with consequential benefits such as pension. Now, it is on the strength of, my lord, the endorsement given by the finance department that, my lord, the PHC department has issued the impugn order, which has been put to challenge here, that they are not entitled for regularization.
Where is the order?
My lord?
Where is there any order passed?
Yes, my lord. That's, my lord will find that page number 42 of the writ petition. That is the last page.
42.
42. Page number 42. It is this order whereby the regularization, claims for regularization of, my lord, the services of the petitioners that has been, my lord, negated, turned out. That is put to challenge.
It is not clear, Lordship, whether it is of petitioners or some other persons, because it is in a common order, name has not been reflected.
It is a part of the prayer, my lord. That's
Yes.
Kindly move over here.
What is the date?
Date even, my lord, they say it, my lord, February 21, because they, some, my lord, it has become illegible, my lord. Page 42. Now, in the prayer portion at page 16 of the writ petition, my lord, they are praying for setting aside of this order. Now, this order down below, lordship will find With reference to the letter cited above, I am directed to return here with proposals in original and to convey to you the view of Finance EC2 Department in their so and so for kind information necessary. The Public Health Engineering Department is informed that as per Honorable High Court's direction dated 8/6/2017 in WS so and so Upendas, master role workers and casual workers are not entitled for regularization of their service with consequential benefits such as pension, etc. So this is exactly, my lord, the language that has been employed in paragraph 23 of Upendas, my lord. Now, I was reading, my lord, paragraph 4, my lord. At page
This is the impugned order.
Yes, this has been impugned.
Let us see the prayer.
Yeah, prayer at page 16. Even they could
Oh.
not connect, my lord, that it is their proposals which have been, my lord, turned down. Page 16.
Okay, yes.
Page 16. They have put this order to challenge, but the writ petition is absolutely silent whether this order would mean and include the rejection of their cases. Nonetheless, my lord,
But their challenge means that they are affected by this.
they are affected by this.
That it is implied that their names may not be written, but it's a general policy adopted.
When policy adopted. Now, whether, my lord, a policy that may be adopted, whether the court can issue mandamus, that is also, my lord, spelled out in my affidavit. So if I have just read paragraph 4 of my affidavit at page 45, my lord, to bring home the fact, my lord, that how this impugned order, my lord, came to be issued. Now, my lord, I am reading the next question, my lord. Paragraph 4. It may be down below, my lord. It may be mentioned that the Honorable Guwahati High Court in its order dated 8/6/2017, Upendas has viewed that master role workers and casual workers are not entitled for regularization of their services with consequential benefits such as pension, etc. Now, paragraph 5. So what had happened way back in the year 2005, that has been spelled out at paragraph 5, that the Finance Department, as per decision of the Cabinet, dated 22/7/2005, had later dated 22/8/2005, granted approval for regularization of 5892 workers and 25069 master role workers of different government departments engaged prior to 1/4/1993 and in continuous service without break, since their engagement by creating posts created specifically for the purpose of regularization. However, it is not known whether the PSC department submitted proposal for regularization in respect of the petitioners during that period of 2005. So there are no materials from record. And even, my lord, the writ petitioner has failed to establish on record, my lord, that some proposals were sent way back in the year 2005, but they had been, my lord, illegally turned down, or they were kept outside the purview of regularization at that relevant point of time. Now, paragraph 6 will assume importance here, my lord. Paragraph 6, that the services of some workers and master role workers could not be considered by the government at that time because of restriction imposed by Honorable Supreme Court of India in the case of State of Karnataka, Uma Devi, reported in so and so. And by the Honorable Guwahati High Court in Jitendra Kolita case. Now, this is a full bench decision, my lord. Lordship is aware about this, Jitendra Kolita. Later, a miscellaneous case was filed by the Chief Secretary to the Government of Assam in miscase number MC 597 of 2012, seeking the leave of the Honorable Guwahati High Court to frame and implement the draft policy for regularization of the services of the master role workers, casual workers, and other similarly placed workers who were engaged prior to 1/4/1993 and in continuous service since then. However, the Honorable High Court, by its order dated 27/3/2012, was pleased to dispose of the same by stating that if the state cannot regularize casual workers as per law laid down by the Honorable Supreme Court in Uma Devi, the High Court cannot give directions to adopt a policy.
Justice Goyal's order.
Yes, my lord, that lordship will find, my lord, that.
I think it's Justice Goyal's order.
Yes, page 55. Page 55 of the affidavit. Is the last page, my lord.
Yes.
May I read it, my lord?
We know this order.
Yes.
Division bench authored by Justice Goyal,
Yes.
Chief Justices.
So the
Second last paragraph, if the state cannot regularize.
Yes, my lord. Second, if the state cannot regularize casual workers as per law laid down, my lord, It is however made clear that it is the responsibility of the state to
What is
appoint.
the date of this order?
My lord, it is, my lord, 27/3/2012. 27/3/2012. That is miss case number 597 of 2012.
27/3/2012.
So therefore, it is evidently clear on record, my lord, that the petitioner at no point of time, right from initial engagement, my lord, till, my lord, his their superannuation or whatsoever, my lord, had worked in any sanctioned regular vacant post. So apparently, my lord, their claims are not covered with the exception carved out at paragraph 53 in Umadevi's case. That is my first submission. Second submission, that, my lord, in view of the dictum pronounced by the division bench of this court, my lord, in Upendas, paragraph 23 is clear. If I may read it, my lord, for the reasons stated, we are of the view that in the fact situation of the case, master role workers, workers, and casual workers are not entitled for regularization of their service with consequential benefits, such as pension, etc. We accordingly, subject to our so allow the appeal. So they are not entitled that much.
Anything else?
That much.
Yes,
I'm
madam,
obliged,
anything
my-
else?
Also, the PhD department in their affidavit has not controverted any of the statements made in the repetition lawsuit regarding their promotion, everything, all this lawsuit conversion. They have admitted all these facts. And therefore, lawsuit, and there is also no answer to the PhD department lawsuit why they were not considered whether anything illegal was their lawsuit that they have not considered petitioner's regularization. There was lawsuit petitioners are entitled in 1993, 2005. They were, as per your finance department affidavit, more than 5,000 of the master role employees were regularized.
No,
Before
those
Umadevi case lawsuit.
Those cases were considered pursuant to some orders of this court.
No, lawsuit in 2005, before Umadevi's case lawsuit.
No, those were considered
Lawsuit.
in terms of some orders of this court.
No, lawsuit. It was a regular process. Lawsuit.
No, some court cases were mentioned.
Lawsuit.
There
In
was
2019, the regulation made in 2019, these were lawsuit as per the order of this honorable court in 2019. But before Umadevi's case lawsuit in 2005 itself, as per the finance department affidavit lawsuit, more than 5,000 or something lawsuit they have regularized.
You did not come to the court at that time.
Lawsuit.
If you are aggrieved, you should have come immediately. That some 2,000, 5,000 people who have been regularized, we have been left out. You did not come there. In the meantime, Upendas came, Umadevi came, and you came at the fag end of your career.
At,
You were 59 years when you had filed this.
In 2011, also all the reported employees were regularized with effect of 2011.
So when did you espouse your cause of action?
First in 2021, I have filed.
At the time when you had attained 59 years of age.
Because
if you thought that you had a cause of action, you should have come to the court immediately.
Plus, if they were expecting the regulation as per the, along with the other similarly situated.
Waiting for the fag end, and in the meantime, there are pronouncements.
Maybe lots of pagan, but they are also entitled to the equal treatment along with other.
No, unless you come to the court on time, when the law was not, Upendas was not there, Umadevi was not there. There were many hundreds of regulation, all appointed after 1/4/1993. Court said past order, but matters have changed after Umadevi.
At that time, since they were in the Suresh Board lawsuit from 1990 to 2011, they were in Suresh Board, and maybe lawsuit since.
When was Umadevi decided? What is the date, Mr. Borpujari?
This is on 10/4/2006.
No, 2006.
2006, 10th of April 2006.
And as
Madhav has already come. Paragraph 53.
other two conditions. they
Okay,
put
we'll,
in Lordship.
we'll dictate this at 2 o'clock. Not.
My lord, I have a small player, my lord, in respect of item number 21, my lord. There is some urgency in item number 21, my lord. But because of some difficulty, my lord, I have to leave the court, my lord. This matter may be taken on next Tuesday, my lord. Petitioner has been dismissed from service, my lord, on alleged negligence, my lord. He has
What is the urgency?
my problem today, my lord.
No, why on Tuesday?
Tuesday, my lord, petitioner has been dismissed from service.
So,
He has
23 matters, there are many matters.
minor children, my lord.
Hmm?
Minor children, my lord. On the ground of
Minor
alleged,
children, so it's a dismissal matter. It's 23 matter.
alleged negligence, my lord. Negligence
We'll
of
not fix a date, we'll have, say after 2 weeks. We'll accommodate you, you go. Today will not pass any adverse orders. You have made a prayer, we'll definitely consider. We will not fix a date. 23 matter, that to dismissal matter. There are many other matters. We'll fix a time after 2 weeks. Okay,
my possible method after 1 week, my lord.
we'll pass orders when it reaches. It may not even reach. If it doesn't reach, then there are many matters now. Mr. Chaudhary is waiting. NIT matters. এটা indicate করেছে 20%. এটা মই একটু 2টা বজাত ইয়াতে দিম দে. Okay.
No, like.
And Mr. Bodloy for the corporation
yes.
department. Okay, when, tell us when. 9 is connected with 10.
Yes, Your Lord.
10, who is appearing in 10? 10, who's the council in 10? If 9 goes, 10 will also go.
Similarly situated, madam.
No, do you know the council appearing for 10?
I'll inform, madam.
Okay. When do you want?
Next week. On a hearing day, madam. Any day, madam.
Next Tuesday?
Next.
Okay. 9 and 10, huh? On a request made.
I'll inform the petitioner.
You are making the request. Okay. You
Both
are,
of us together.
okay, on a joint request made, list these cases for, on Tuesday next.
Deeply.
Date. এখন হয়ে গেছে এখন এখন নতুন দিব এখনটো অলপ আছে এখন দি থৈ দিয়া এখন ৰেডি কৰি থবা এখন শেষ হৈছে এনেকুৱা ইয়াতে আছে আছে নে আৰু নতুন Two petitioners have joined together in this petition filed under Article 226 of the Constitution of India, making with the following relief. Quote kar dijiye, page 16. Quote kar. Para. The facts projected is that the petitioners were initially appointed as work charge employees in the Public Health Engineering Department in the year 1988. Full stop. In the year 1990, they were deputed to the Assam Sweres So-and-so Board, wherein their services were also upgraded. Full stop. In the year 2011, the petitioners were reverted back to the parent department of public health engineering. पहले PHE within bracket लिखना, PHE. Full stop. The petitioners had sought regularization of their services. Full stop. However, by the impugned decision taken on February 2021 by the department, comma, the cases of regularization has been negated. Full stop. It is this order which is the subject matter of challenge with a further prayer for a direction to regularize the services of the petitioners. Full stop. I have heard Ms. R. Devi, learned counsel for the petitioners. Full stop. I have also heard Sri I. Borthakur, learned counsel representing the public PHE department, and Sri R. Borpujari, learned standing counsel representing the finance department. Full stop. Para. Ms. Devi, the learned counsel for the petitioners has submitted that the petitioners have rendered long period of service from the year 1988, and this petition was instituted while the petitioners were still in service. Full stop. Though the petitioners have retired in the meantime, comma, in absence of an order of regularization, comma, they are not getting their post-retirement benefits. Full stop. By referring to the documents annexed to the writ petition, comma, the learned counsel for the petitioners has submitted that when the petitioners were reverted back to the PHE department via order dated 6/4/2011, comma, such reversion was with their respective posts. The learned counsel has emphasized on the issue that the petitioners were upgraded in their services while they were deputed in the swearers board. Full stop. Attention of this court has also been drawn to a communication dated 13/4/2011 of the department, wherein a proposal for regularization and retention was made. Full stop. The learned counsel has also relied upon an order dated 23/3/2017 of this court passed in WPC 3476 of 2016, wherein there was a direction for consideration of regularization. Full stop. The learned counsel accordingly submits that in the line of the aforesaid order dated 23/3/2017, comma, a similar order be passed for regularization of the services of the petitioners. Full stop. Para. Per contra, comma, Sri Borthakur, the learned counsel representing the PHE department, has submitted that the records which have been enclosed to the petition do not even suggest that the initial appointment of the petitioners were in a vacant sanctioned post, which is one of the preconditions laid down by the Honorable Apex Court in the case of State of Karnataka versus Uma Devi 3, reported in 2006, 1 SCC 1, and therefore the question of regularization would not arise. Full stop. By referring to the order dated, communication dated 27/9/2019, relied upon by the petitioners, which pertains to 3 employees of the department whose services were regularized, comma, the learned counsel has submitted that the said order was passed in terms of an order of this court of the year 2012 and was also a conditional order that the regularization was purely temporary and could be reverted without assigning any reasons. Full stop. He submits that after the case of State of Assam versus Upandas reported in so and so, comma, the scope of regularization has become absolutely minimal, and unless an incumbent meets the requirement laid down by the Honorable Supreme Court in the case of Uma Devi Supra, comma, such regularization cannot be directed. Full stop. Para. Endorsing the submission of the department, comma, Sri Borpujari, R. Borpujari, Learned Standing Counsel Finance Department, has submitted that a bare look at the initial order of appointment dated 29/3/1988 would show that the same was not against any sanctioned vacant post. Full stop. He has also highlighted the aspect that the order was issued by the executive engineer and not by the government. Full stop. By referring to the reversion order dated 6/4/2011 and the chart appended thereto, comma, the Learned Standing Counsel has submitted that unlike other incumbents, comma, so far as the petitioners are concerned, comma, there was no information on creation of the post. Full stop. He submits that it indicates that the petitioners were not appointed against any sanctioned post, and therefore the question of regularization would not arise. Full stop. The Standing Council has also submitted that the order dated 23/3/2017 relied upon by the petitioner passed in WPC 3476 of 2016 was not a mandamus per se and was only an order of consideration. Full stop. The so far as regards the regularization order pertaining to some other incumbents, comma, the standing council has submitted that such regularization order cannot be held to be a binding precedent as the same was issued by the executive engineer and not by the competent authority. Full stop. It is the said regularization order also does not indicate that there was any approval by the government. And in any case, there is an express clause that the regulation order was temporary in nature. Full stop. By drawing the attention of the affidavit in opposition filed by the Finance Department on 9/12/2022, comma, the learned counsel has submitted that after the authoritative pronouncement by the Honorable Division Bench in the case of Upenda Supra, comma, a direction for regularization cannot be issued. Full stop. The learned counsel has also referred to the impugned order of February 2021, whereby in view of the law laid down in Upenda's case, comma, the proposals were returned, which cannot be found fault with. Full stop. Attention of this court has also been drawn to an order dated 27/3/2012, passed by a division bench of this court in Miss Case 597 of 2012, whereby there is a categorical direction that categorical finding that no direction can be issued by the court which is contrary to the law laid down by the Honorable Supreme Court. Full stop. The learned standing council has also specifically referred to the observations made by the Honorable Division Bench in paragraph 23 of the Upenda's case. Full stop. Para. The rival submissions have been duly considered and the materials placed before this court have been carefully examined. Full stop. The issue of regularization has been one of the matters for consideration before the courts from time to time. Full stop. At one instance, comma, the state government had taken taken a step to regularize master roll and work charge employees who were appointed prior to 1/4/1993. Full stop. However, the issue was finally resolved by a division bench of this court in the case of Upendas Supra, wherein the plea of the state was accepted by the court, and it was held that by only by the length of service rendered, comma, an incumbent does not per se become entitled for regularization. Full stop. The Honorable Division Bench in the aforesaid case had taken into consideration the law holding the field as settled by the Honorable Supreme Court in the cases of in various cases, including the case of Uma Devi. 3, Uma Devi, supra, full stop. In paragraph, in the case, said case, comma, the Honorable Supreme Court had made the following observation. Paragraph 53, quote. The Honorable Division Bench, by following the law laid down, had negated the aspect of a claim of regularization, and it was only on a concession made by the court, made by the state, that certain observations were made for payment of the minimum of wages to such employees. Full stop. Para. In the instant case, comma, the petitioners have relied upon an order dated 27/9/2019 pertaining to certain employees of the department. Full stop. A bare look at the said order would reveal that the same was passed by the executive engineer and was a conditional one. Full stop. It also appears that the order was passed pursuant to certain directions of this court passed in WPC 6532 of 2011, wide order dated 26/7/2012. Full stop. Apart from the fact that such directions were issued prior to the decision in Upenda's case, comma, the consequential order is also a conditional one, which cannot be a binding precedent. Full stop. This court, however, makes it clear that while it would be the prerogative of the department to adopt a policy for regularization, which, however, is to be strictly in accordance with law, comma, a direction for regularization cannot be passed by this court in view of the authoritative pronouncement by the division bench of this court in the case of Upendas. Full stop. This court has also noticed that the petitioners do not fulfill the 3 requirements as laid down by the Honorable Supreme Court in the case of Uma Devi. Full stop. Admittedly, comma, the initial induction of the petitioners in service was not against any vacant sanctioned post. Full stop. In view of the aforesaid facts and circumstances, comma, this court is of the considered opinion that no relief can be granted to the petitioners in this case. Full stop. The petition is accordingly dismissed.
Obliged.
Yes, next.
I did 4 and 5.
NIT.
Yes, I'm for item 5. What was here? 4.
May I present a lot, Lord, this matter is also somewhere connected with the issue of regularization, my Lord. Lord, the petitioners were appointed long back in the year, someone in the year 19. We have given a detailed chart, my Lord, regarding our date of appointment. Okay, page number. My lord, I am troubling my lordship for that, page number 8.
You are in 5046.
My lord, 5046.
Okay. How many cases are there?
Only 2 writ petitions. my lord.
Mr.
Ma-
Borwa is for in the
My
second.
senior friend is for 5 million.
5406.
Yes, another pending.
Okay, doesn't matter. Do you take?
My
We take up which matter first? 5406.
My lord, 5406 is the, my lord, leading case. 5046, my lord, item number 4, my lord.
Oh, my numbers are also matching.
My lord, some visits are here and there. So, my
Mr.
lord,
Chaudhary, you're in you'll be in some difficulty. They will even now match the numbers.
Yes, 5046 and 5406.
5406.
Otherwise, easy to remember. The case.
Okay. Yes, 5046.
my lord.
Okay.
My lord, I beg to draw my lordship's precious attention to page number 8, my lord.
Page 8.
Page 8 of my writ petition.
Our
where-
attention is not precious, Mr. Bhuya. You make your submission
Mal.
generally. You
Mal.
do not use those expressions.
My lord,
We don't like those expressions.
my lord, I'll take
We are
care.
doing our duty, you are doing your duty.
My lord.
What is so great about it?
My lord, it's a, my lord, turn out to be an habit, my lord.
Don't make it, somebody may like, I do not like.
My lord. Take care, my lord. Is at page 8, my lord, is the petitioner number 1. Date of joining, my lord, may be pleased to find is at 1/7/1995. my lord.
Manzurul is number one.
Petitioner number 1, my lord.
Okay.
Then, my lord, petitioner number 2 is of 1992.
These are the serial numbers or the indications of the numbers of the petition?
Petitioners, my
Okay,
lord.
okay.
No? Yes, my lord. And the serial number 3 is the petitioner number 3 also, my lord, of 1997. Then, my lord, serial number 4, 2000, my lord. This is the almost, my lord, they have
You
rendered.
have given the rank and their date of joining.
My lord.
Okay.
Now, my lord, the issue of the, my lord, these present petitioners, my lord, earlier did also approach before this honorable court,
Hmm.
claiming their regularization, my lord, and the
They are working where?
working in the, my lord, NIT Silchar, my lord.
At the time of joining, it was what?
My lord, it was at the Regional Institute of Engineering, my lord.
It was earlier REC Silchar.
My lord, REC Silchar, my lord, at the time of our appointment, my lord. And, my lord, then, my lord, once we are working, my lord, then a process of, my lord, selection had also been undertaken earlier. Then, my lord, we did approach before this honorable court also, my lord.
Page.
My lord, yes, my lord, is at page 33, my lord,
33.
annexure 4 to my petition.
You had come or somebody else had come?
My lord, we were also there and some other persons were also there, my lord. Similarly situated, my lord.
719.
My lord. WPC 719/2007 and is at page 34, my lord.
Yes.
Being aggrieved for non-regularization of their services, 25 writ petitioners who are all master rule workers working in the National Institute of Technology, for short, formerly known as the Regional Engineering College RSC Silchar, since long are before this court praying for issuing a writ of mandamus directing the respondents to regularize their services. Petitioner case in a nutshell is that they are the employee of the NIT Silchar working as a master rule workers against grade 3 and 4 posts. They have already put in the most of the valuable years in their lives for the cause of the said institute. As such, they deserve regularization of services so that they can get regular pay scale, etc. There are 3 categories of master rule workers in the institute, that is the skilled, semi-skilled and unskilled. The petitioner number 1 is a skilled master rule workers and an ITI diploma holder, and as such, he is being paid rupees 102 per day as daily wages. The petitioner number 2, 3, 6, 14 and 22 belong implementation of the resolution number 8 is quoted herein below. Regularization of the master rule workers as and when vacancies exist, the master rule workers will be regularized as far as possible according to their trade and grade. But nothing has been done for regularization of their services of the petitioner as per the above resolution till date. The petitioner came to know that the wide letter dated 13/9/2005 as the Ministry of Finance Department of Expenditure imposed ban on creation, upgradation,
Is it
regular.
required to read the entire order?
My lord, may can skip, my lord, the,
Read the operative.
yes,
part?
yes, my lord, the operative part is at page 41, my lord.
Yes.
Therefore,
Hmm.
in view of the above position, no direction can be issued at this stage to the authority of NIT to regularize the services of the petitioner. However, taking into consideration the length of their services as some of them as continuously in service since 1980, 82, and 85, etc., it is directed that whenever the ratio of 1:1:5 between the faculty and non-faculty member achieved, the petitioner case shall be considered taking the respective length of services into consideration. The authority shall also consider the case of the petitioners belonging to SC/ST while filling up the backlog vacancies pursuant to the communication dated 1st of June 2006. With the above direction, the writ petition is disposed of. Now, my lord, this order of the learned single judge had been carried to an appeal, my lord. My lord, may be pleased to find the appellate order is at page 45. And skip, my lord, the page 46 operative part, my lord. Last paragraph.
You
my
had
lord.
filed WA.
Yes, my lord. Read appeal number, my lord. 369 of 2008, my lord. I am referring to, my lord, page 46, the last paragraph, my lord.
46.
46, yes, my lord.
Yes. What is the date?
Having regard to the above facts that the
Date 5/12.
mile.
Yes.
Mal.
yes.
Having regard to the above facts that the appellants have already served for more than 30 years and they are still continuing in service, it will be the interest of justice that the issue is considered again by the National Institute of Technology, Silchar, as well as by the Ministry of Human Resources, Government of India, as far as possible within 6 months from the date of receipt of the certified copy of this order, pending decision on the issue, the appellants may be allowed to continue in service. If the appellants are aggrieved by the decision which may be taken, they will be at liberty to take their remedies in accordance with law. The appeal is disposed of. So, my lord, there is a direction that the NIT Silchar as well as the Ministry of, my lord, Human Resource Government of India to take a, my lord, final call regarding to take a decision, a reason order, my lord, that whether we can be regularized or not. Until then, my lord, decision is taken, we have been allowed, and the, my lord, NIT Silchar is kind enough that till date we have been allowed to continue, and we are continuing till date, my lord. Now, my lord, now, my lord, may be pleased to find, we have annexed an important, my lord, resolution of, my lord, dated 27/9/2013, a resolution dated, my lord, notice dated. The relevant part of the resolution number 3 is at page 53, my lord. After the division bench order, my lord.
Which page?
My lord, I am referring to page 53, my lord. 53,
Resolution.
my lord.
A part of the resolution. Number 3 you are referring.
My lord, it is also resolved. My lord has got it, my lord, at
Yes,
page
yes.
53, my lord.
The
It is also resolved
date
that
of the meeting is 27/9.
my lord, yes, this is a reference of 27/9/2013. In the discussion, the following resolution were taken for serving the present ongoing MR oblique daily wage workers problem in NIT Silchar. Resolution number 3. It is also resolved that the existing master rule oblique daily wage workers working in NIT Silchar since last several years are to be regularized from amongst the MR oblique daily wage workers, phase-wise, subject to availability and sanction of the post by the Ministry of Human Resource Development. It is also resolved that the master rule oblique daily wage workers who have got no requisite qualification age in their regularization matter in the present shall be given proper training and to fulfill their requisite qualification and age bar for their regularization matter, the management shall give preference. Resolution number 5, it is also resolved that 15 numbers of more MR oblique daily wage workers shall be absorbed in permanent vacant post of NIT Silchar
by 31st of December 2013 as per norm. My lord, this resolution number 5 as per our instruction has already been, my lord, my lord, acted upon, and this 16 numbers has already been absorbed. Now, my lord, our cases has not been considered. Then, my lord, at page 54, my lord. This is a, my lord, in pursuance to the office of the Chief Labor Commissioner order number dated so, the wages of the daily wage master workers, highly skilled and skilled category are hereby enhanced to rupees 707 million in and 603 per day respectively with effect from 1/10/2020. And my lord, till date we have our salary, my lord, wage has also been enhanced and we are getting. Now, my lord, the difficulty arises. The main challenge which we have been put into, my lord, in this petition is an advertisement is at page 57, annexure 9, my lord. This is an advertisement, my lord, issued on 7/7/2023.
Yes.
My lord, by this advertisement, they have decided to fill up the various categories of posts, including, my lord, the some of the posts wherein we can be, my lord, accommodated or regularized is at page 60, my lord. Senior assistant, essential criteria and technical essential criteria, my lord. We are agreed that as the process of advertisement and the new recruitment has been carried out, we could have been regularized in this post, my lord. And when, my lord, my lordship.
Which post?
My lord, is at page 60. Advertisements, the part of the advertisement is at page 60. My lord. It was
60.
60. My lord, senior assistant and, my lord, the junior assistant. In this category of post, as per our qualification, my lord, we could have been, my lord, regularized, my lord. That's why, my lord, we put into challenge that as there is a division bench, honorable division bench order of this honorable court, my lord.
These
that-
3 posts you can be
Yes, my
accommodated.
lord.
Senior
Only in this
technician.
category we could have been, my lord.
Senior technician.
My lord, senior assistant and, my lord, junior assistant is at page 61, my lord.
Oh, senior assistant.
My lord. Now, my lord, when the my lord matter was moved at the motion stage, my lord, my lordship was pleased to issue notice
Where
of
is junior assistant at page 61?
61.
Yes.
Now, my lord, when we moved this petition, my lord, at the motion stage, my lord, this honorable court was pleased to issue notice, my lord, and in the interim, there is a direction that there should not be finality in the advertisement.
Okay.
That's why, my lord, the NIT Silchar has now expressed urgency regarding that there is an hold in the recruitment process and the interim order should be vacated, my lord. Now, my lord, our case is, my lord, very limited. My lord, as there is a direction and we have rendered, my lord, almost above more than 30 years of service, my lord, since long. So, my lord, there is a direction of the division bench that our cases should be considered, my lord. Either they can go for a positive or negative consideration, my lord. That is the observation. But that consideration, my lord, till date has not come up in a my lord, in a written order, in a written form, my lord. Only, my lord, they have filed an affidavit by the NIT Silchar, my lord, wherein my lordship may be pleased to take up the affidavit filed on.
But what about the resolution they had adopted to
Yes,
consider your cases?
my lord, that resolution has also not been acted upon, my lord. Although the resolution number 5, wherein 16 numbers has
No,
been.
that has been acted.
That has been acted.
3 and 4?
But that 3 and 4 has not been acted, my lord. Regarding that, my lord, in the affidavit also they are silent, my lord. So, my lord, I only, my lord, beg to draw my lordship's attention to, my lord, the paragraph. My lord, running page 81, paragraph 7.
Part of the
affidavit filed by, my lord, the NIT Silchar by the respondent number 2 and 3, my lord, filed on 8th day of November 2023.
Yes.
My lord, I am referring to, my lord, paragraph 7. Is at running page 81, bottom of the page, my lord.
Yes.
That with regard to the statement made in paragraph number 6 of the writ petition, the answering respondent begs to state that although a meeting was convened on 27/9/2013 to discuss about the issue of MR and daily wage workers, wherein the regularization from amongst the MR and daily wage workers would be considered phase-wise, subject to availability and sanction of post by the Ministry of Human Resource Development, was resolved that there is no dispute with regard to the fact that in absence of any sanction post, the services of the writ petitioner have not been regularized, and there being some communication with the Ministry of Human Resource Development to get appropriate approval for such regularization, as there was a specific directive of the MHRD that no fresh recruitment of the Group D or lowest non-technical Group C would be allowed, and there being no scope of regularization of their services since their educational qualification were not as per the recruitment rule. It is necessary to mention herein that, but in view of not obtaining any such specific direction from the Ministry of Human Resources Development, no effective step could be taken to consider the case of the petitioner. It is necessary to mention herein that the petitioners, since not regularized, were given due recognition to their continuous service by providing them various facilities as being given to the regular employees of the institute. The petitioners are very much aware of the fact that in absence of any specific policy of regularization, their services cannot be automatically regularized without following the due procedure of law. It is necessary to mention herein that the BOG NIT Silchar, in its meeting dated so-and-so, had considered the case of the petitioner sympathetically and proposed the following options. The workers will be considered to form a society so-and-so or a Companies Act under Section 25 consisting existing daily wage workers. The works can be outsourced to the society or company. The wage, term of engagement, job, etc. will be guided to the society of the company as the case may be. Thus, the interest of the workers will be safeguarded as the institute believes. So, my lord, this is the policy, my lord, they are adopting, but only by of an affidavit, this is a view has been taken. But, my lord, the honorable division bench order has not yet been complied with till date. My lord. Now, my lord, the issue and the law of regularization, my lordship has already, my lord, is well aware, my lord, from the Uma Devi's case to, my lord, from the Upenda's case of the honorable division bench of our High Court, my lord. That, my lord, that the no mandamus can be issued, my lord. That's why, my lord, it has been left to the authority that you take a decision. And even, my lord, if we go by the Uma Devi's paragraph 53, my lord, we have rendered more than, my lord, 30 years of continuous service as a master rule worker. It is an admitted position, my lord. So considering that, my lord, as we are working from since 1985, although, my lord, the dates varies for some of the petitioners, my lord, before the Uma Devi judgment came, my lord, we were there, my lord. So as a one-time measure, my lord, they could have, my lord, regularize our services, my lord, by following the direction of the Honorable Apex Court. My lord, recently the Honorable Apex Court has also passed a judgment, my lord, a very recent judgment, if my lord.
No, we need not go
My
on
lord.
those aspects.
My lord.
See, there is a direction of the division bench in
My
your case
My lord.
that you consider your cases, and until such consideration,
We should be allowed.
you should be allowed. You have been allowed.
My lord.
In the meantime, they initiate a recruitment drive
My lord.
for direct recruitment, in which case your chance of or scope of being considered would be minimized.
My lord.
Now, without your cases, that without considering your cases in terms of the division bench order,
My lord.
a fresh recruitment at least to the post of
That two
senior
categories,
assistant,
senior and
junior
junior.
assistant should not be made. That is
My
your
lord.
case.
That is our
Prasad.
case.
Mr. Chaudhary,
In
have
our
you
affidavit-
considered?
Yes, in our affidavit, we have clarified that aspect of the matter because the petitioner, they are also overage. So they have been given due consideration. They have been allowed to participate in the recruitment process. They can very well participate in the recruitment process. Because say as per the
No,
division,
participation in a recruitment process is different aspect. That is not a consideration in terms of the division bench order.
no, the division bench. if the
Division
lordship-
bench did not say that you hold a recruitment and ask them to
No, the
participate.
division bench direction, lordship kindly see the direction of the division bench.
Yes,
It is there in page number 46. The operative portion is at page number
5.
45. And the last paragraph is at page number 46.
Yes.
Having regard to the above fact, the appellants have already served for more than 30 years and they are still continuing service. It will be in the interest of justice that the issue is considered again by the National Institute of Technology Future, as well as by the Ministry of Human Resources, Government of India, as far as possible within such and such date. And the applicants may be allowed to continue service. They are continuing the service. Lordship,
yes.
And moreover,
No, the first part, don't hurry up.
yes, within 6
Having-
months from the date of
having
receipt.
having regard to
Yes.
the above facts and facts that the appellants have already served
For more than
for
30
more
years.
than 30 years and they are still continuing in service.
It will be in the
It
interest
will
of
be
justice.
justice that the
Issue is
issue is
considered
considered again,
Again by the
as well as by so and so, as far as possible within 6 months
from the
from.
date of receipt of the certified copy of this order, pending decision of the issue, the appellants may be allowed to continue.
Now, have
service.
you considered them?
So the thing is that lordship, I have annexed certain documents and there are certain other documents also which I have not annexed. The repeated communication has been made with the MHRD and the communication that has been received in our affidavit also we have clarified that aspect of the matter. Since the initial entry was not with regard to any vacant sanction post.
Mr. Chaudhary,
yes.
you are open to make all this submission.
Yes.
But you consider and reject them.
No, that part is always there, lordship.
No,
But the fact is
always
that-
there, but have you done it?
But the difficulty on the part of the institute is that so long as we are not getting any approval from the MHRD, we cannot proceed with that.
MHRD, yes, Mr.
Because-
Gogoi, right on
because the-
time.
MHRD. That part, no, say I have to, otherwise.
See, matter is a very simple matter. We have a direction of the division bench which has attained finality. Division bench has not said regularize their service. Division bench has said that taking into account the reasons cited by the honorable single judge while declining an order for regularization, division bench has taken into consideration the 30 years they have served. So it it warrants a reconsideration by the NIT in collaboration with your ministry, and till such reconsideration done, allow them to continue in their service, which they have been allowed. Now the fresh recruitment process has been initiated, including two categories of senior assistant and junior assistant, where according to the petitions, they can be accommodated. Now we only want a consideration and passing of the final orders. And because division bench has not ended there, division bench has added one more line. If the appellants are agreed by the decision, they can come to the.
For that consideration.
That means your consideration is a must.
For that consideration part of the MAC proposal is not required. MHRD proposal is not required. It's by the Lordship Institute itself.
Oh, let us see the language employed.
Lord.
It will be in the interest of justice, the issue is considered again by the NIT as well as by the ministry. You take a decision.
Lordship, they can independently take the decision.
Take a decision.
But the fact is that lordship, I have just now made a submission with regard to the document that.
Mr. Bhuya and Mr. Barua, how many of you are there?
Lord, we are 10 in my petition, my lord.
I am from the association, my lord. Another two category, that is technical and senior technician. My learned friend has not, because his client is not technician.
No, are you also covered by the earlier
Yes,
decision?
same, CND, advertisement, CND.
Mr. Chaudhary,
Yes, Lord.
the numbers will not be a big consideration for
Yes.
you or a
Yes.
trouble for you.
Yes.
It is only a matter of, you may consider en masse. You can consider individual wise. Even if you consider individual, it will not take more than 2 days.
Yes.
You see the antecedent, take a policy decision. Yes, we are regularizing. No, we are not regularizing. But you have to cite reasons. Because division bench has said that if they are aggrieved, they can come to the court again. How much they will be successful or not, it's a different matter. We cannot contemplate now. It depends on the reasons cited by you. But why don't you finish this matter?
Lordship,
The
kindly
ball
see-
is in your
Lordship,
court.
kindly see the paragraph number 7, which my learned friend just now referred to.
Of
Paragraph number 7, page number 81 of my affidavit in opposition.
yes.
Why I am saying about MHRD, lordship, because it is there in paragraph number, page number 82.
Hmm.
Let's start from page number 81, Lordship, paragraph 7.
Yes.
That with regard to the statements made in paragraph 6 of the writ petition, the answering respondents beg to state that although a meeting was convened on such and such to discuss about the issue of MR and daily wage workers, wherein the regularization form amongst the MR and daily wage workers could be considered phase-wise subject to availability and sanction of post by the MHRD was resolved. That there is no dispute with regard to the fact that in absence of any sanctioned post, the services of the writ petitioner have not been regularized, and there being some communications with the MHRD to get appropriate approval for such regularization. As there was specific directive, this is important, Lordship, as there was specific directive of the MHRD that no fresh recruitment of Group D or lower non-technical, lowest non-technical Group C would be allowed, and there being no scope of regulation of the services, since their educational qualification are not as per the recruitment rules. So there is some restriction on the part of the MHRD. The difficulty is with regard to that restriction on the part of the MHRD. That is the reason why, Lordship.
We are not here to advise you.
Yes,
You
Lordship.
can take a resolution that we sought advice from the MHRD, not coming. Yet there is an order of the court. We want to go ahead with the recruitment process. So we sit, we consider, if we find that they're entitled for regulation, regularize them and fill up those posts in daily on regular basis. Otherwise, you know what to do. You can decline the regularization by citing reasons.
Because the
What is the difficulty of MHRD? Why didn't you issue some guidelines that in terms of this court's order, follow these guidelines? You can refer to Umadevi, you can, whatever you want to do, you do. End the matter. Ultimately, who's suffering? The institution is suffering.
exactly. Lord.
At the same time, we do not want to cause prejudice to the petitioners. They are armed, equipped with an order of this court.
No, they are otherwise not going to be prejudiced anyway, Lordship, because they are continuing with the service. Because
No, their continuation, Mr. Chaudhary is saying that simply will not do. Why do you say they are not suffer prejudice? If tomorrow you hold them to be entitled to regulation, there are no posts. It will be a futile exercise. Now some posts have been, they have identified certain posts where they can be.
no, they have been allowed to participate. They did not participate, Lordship. They have been allowed to participate. Why they
That's a
did not-
different matter. They did
Yes.
not, if they do not participate, it's up to their own peril. But that is for direct appointment. They do not want to be a direct appointee. They want regularization of the service. How much they'll be successful or not depends upon you. You take the decision. What is in between you and the decision to be taken?
No, the fact is that, Lordship, when the division bench order was passed, that was in the year 2013, I suppose, Lordship. 2013.
Why have you waited till more than a decade?
Yes,
You
Lordship.
sit down, you
Because
take a
of-
decision, you cite reasons, consider.
Because we have explained that aspect of the matter in our affidavit, Lordship. Because
No,
the fact is
affidavit
that
is,
we are
affidavit is not,
communicating. Yes.
affidavit is not a decision, affidavit is.
No, we are expressing our difficulty with regard to this taking a final call with regard to the regularization. Is the fact that this MHRD have been approaching the MHRD, and there is some sort of restriction with regard to the sanction vacant because the Umadevi judgment is clear with regard to the fact.
You cite those in a resolution. You cite all those facts in a resolution and MHRD give them a guideline.
That's also on the basis of that, the paragraph which does without law, on the basis of.
And
that,
this,
there is
this
no-
embargo which we are giving now,
Yes.
we cannot remove the embargo. And this embargo, if it continues, that is not serve the interest of justice also. We don't want a post to be kept vacant like this. We have delayed the matter. More than a decade has passed. You need to sit down and take a decision
No,
in
delay.
accordance with law. Convey it to them, matter ends there.
The fact is that, Lordship, what we have stated in our affidavit also, that aspect of the matter we have.
Mr. Chaudhary,
Yes.
affidavit is contesting a case.
Exactly, Lordship. We are basically
That is not
verifying the
resolution.
stand taken by the institute.
You
Lordship.
can make this affidavit a part of your resolution. Sit down consciously. It should not be a mechanical exercise. There is a direction of the division bench. Take a conscious decision, convey it to them. And this you should do for your own good. Mr. Chaudhary, for your own benefit, you should expedite this, not for them alone. Expedite this, finish it. Is there a restriction?
No, there is otherwise no restriction
Then-
with regard to that. Because at any
In
point
fact,
of time,
when
you
this
can-
matter
yes.
was filed, immediately you would have said, no, we are sitting down, taking this resolution, press it before the court, matter ends there. And we are not here to again reiterate what the division bench has said. Why should we? And they have all the rights to say that, yes, division bench has asked for a consideration and continuity. And if in the meantime you fill up the post, whether you're continued or not, we have lose a chance of an effective chance of being regularized. Mr. Gogo, you can also advise your client, resolve the issue
I got it.
for your own interest.
Otherwise, lordship, on the basis of that take up, they can take decision law. They can take decision law. Either this way or that way.
On the basis of?
On the basis of the paragraph, just.
No, paragraph is there, it's their narration.
They are relied in law.
No, it's a narration, it's a paragraph by them. It's
Not-
based on what?
Affidavit, yes.
Paragraph is based on what? Is there a document?
It says that lordship, they
No,
have,
is there a document to base the pleadings, averments?
they are, in the oath, they have said that there is a part from the MSRD.
Where is the document?
And lordship, they have.
No, where is the document?
No, that document I can place, if your lordship directly
No,
I can place. It's
take the document as your.
part of our, this resolution.
Of that, they can take
You
decision.
take a
lordship.
decision,
Take a
take a
decision
decision,
to look upon.
take a decision as soon as possible. Do not delay the issue. And let them, deal with them fairly.
No, we are otherwise not dealing in any way which is.
No,
which is
fairly,
adversely affecting the-
fairly so far as consideration is concerned.
Exactly, because
Whether they participate or not, that's a different aspect. If they do not participate, they lose the chance of being a direct recruit. Maybe they are overaged also.
Hmm.
Okay, how soon? Can you take a decision?
15 days at least not.
15 days, we'll keep this pending. You come up with a decision, because if we leave it to you again, there'll
No,
be a
lordship may
stalemate.
dispose of this matter, giving a direction to pass an order within a period of 15 days. Because here in this case, they are basically, if your lordship kindly see the prayer portion of the first petition.
I have one point I want to add with my.
Yes.
I like that. He is related to Umar Devi, my lord. In my affidavit in the reply, I have distinguished that
Mr.
our
Barua,
cases.
that decision is not before us.
Yes. My lord.
No, why are you arguing this? Have they declined the,
No, my lord.
then let them take a decision. You reserve your energy.
Fine.
If it is against you, then you argue. They may take a decision in your favor.
in
See,
judgment.
see, if the authority, on their own wisdom takes a decision to regularize, we have nothing to say.
Yes.
But we cannot direct your regularization, which the
Yes.
division bench has observed.
Yes.
Division bench says that 30 years you have served.
Yes.
Let there be a reconsideration. And until such reconsideration is done, you should be allowed to continue,
Yes.
which you are being doing.
But 3 points, my lord, 53, that is satisfied. That is the competent authorities.
Let them first take a decision,
Yes.
negating, then you can come, no,
And
if it's
against the
satisfied.
sanction post, we are still continue in that sanction post.
Okay.
And there is a panel, selected panel. After that, they had a conspiracy to outsource us, that the regular post will be kept vacant.
Okay,
So that is,
heard. 3,
one thing, my lord, they
Yes.
have already given some appointment, conditional appointment in technical post, my lord, although there is a injunction petition. So that may be not finalized, my lord. I have filed a petition 2502 of 2024 challenging that appointment.
That aspect of the matter already been taken care of by this particular, the subsequent writ petition, because the similar plea was taken before, while placing this matter. And since there was no stay order by this specific stay order by this honorable.
There, your
Yeah,
lordship has
specific-
given stay order because this covered by 5406, your lordship has said on his submission that it will cover. After that, they said, no, there is no stay in that case. My lord, 15.9 and 1.9 order of my writ petition, my
Okay,
lord.
let us dispose these two petitions first.
5406,
Ah.
my lord.
Both these writ petitions being connected with the same subject matter, comma, the same are taken up for an analogous hearing and are being disposed of by this common judgment and order. Full stop. The petitioners in both the cases are employees in various what do you call, cadres?
C and D, but that means grade 3, grade 4.
And in C, in grade 3, in grade 3, in what do you call?
C and D level, because in
Level
group
C,
group
level, group.
Group C and
In
group D
group
level.
C and group D. In group C and D. In the, what do you call, National Institute of Technology,
Yes,
Silchar,
NIT Silchar.
within bracket, formerly REC Silchar. Full stop. On the aspect of regularization of their services, comma, the petitioners had earlier approached this court by filing WPC 719 of 2007. Full stop. The learned single judge, wide order dated 17/1/2008, had, however, declined the prayer for regularization. Full stop. The petitioners had preferred WA 369 of 2008. The Honorable Division Bench, after discussing the facts and circumstances of the case, and also the aspect that the petitioners had rendered more than 30 years of service, comma, a direction was made for reconsideration of the aspect of regularization by the NIT Silchar as well as by the Ministry of Human Resource, comma, Government of India, within a period of 6 months. And till such decision was taken, comma, the petitioners were required to be allowed to continue in service. Full stop. It was also stipulated that if the petitioners were aggrieved by any decision to be taken, comma, they would be at liberty to seek legal recourse. Para. The petitioners claim to have continued in terms of the aforesaid order. Full stop. However, the reconsideration as directed has not been done. Full stop. In the meantime, comma, on 7/7/2023, an advertisement was issued by the NIT Silchar for filling up various posts. Full stop. The petitioners are aggrieved that if the post where they can be accommodated, public regularized, are filled up by direct recruitment, comma, the consideration aspect would be frustrated, whereby the petitioners would suffer legal prejudice. Full stop. It is in this context that the present petitions have been presented. Para, I have heard Sri so-and-so in WPC so-and-so, AR Bhuya, and MJ Borua for WPC so-and-so. I have also heard Sri SP Chaudhary, Learned Standing Council, NIT Silchar, comma, Sri K. Gogoi, Learned CGC, appearing for the concerned Ministry of Human Resource. Anyone else? State government, not a party. Para. The Learned Council for the petitioners have submitted that without a consideration being made in terms of the order dated 5/12/2012 passed by the Honorable Division Bench in WA 369 of 2008, comma, filling up of the post in which the services of the petitioners can be regularized would not only be unfair, but would also amount to circumventing the order of the court. Full stop. It is submitted that if the posts are filled up, comma, a fair consideration can never happen, in which case, comma, the petitioners would lose a chance of being fairly considered for their regularization. Full stop. It is submitted that though the petitioners have been allowed to continue in service, comma, the continuation in service is not the issue, and the issue is for regularization of their service, which is yet to be considered in terms of the aforesaid order of the Honorable Division Bench. Full stop. The learned counsel for the petitioners have also drawn the attention of this court to certain resolutions adopted by the NIT on 27/9/2013, which, comma, amongst others, were on the aspect of regularization of the services of the master role / daily wage workers phase-wise, subject to availability and sanction by the MHRD, and also to impart proper training to those MR / daily wage workers who did not have the requisite qualification and age in the matter of regularization. Full stop. It is submitted that apart from the aforesaid matters which were part of resolution number 3 and resolution number 4, comma, there was another resolution for absorption of 16 numbers or more of master role / daily wage workers which were duly fulfilled. Full stop. Full stop. It is submitted that having taken such resolution, comma, it was incumbent upon the NIT to make a fair consideration in terms of the order of this court as well as the resolution adopted and convey the same to the petitioners. Full stop. Sri Barua, the learned counsel, has also highlighted the aspect that his clients fulfill all the 3 conditions
Yes.
laid down
Section 50.
laid down by the Honorable Supreme Court in the case of State of Karnataka versus Uma Devi 3 Supra, reported in 2006, SL 3 SCC page 1. Full stop. It is submitted that his clients were initially appointed in vacant sanction post and have the requisite qualification, and their continuation in service is not on account of any interim order passed by any court. Full stop. Para. Per contra, comma, Sri Chaudhary, the learned standing counsel NIT, by referring to the affidavit in opposition filed on 10/11/2023, has submitted that the petitioners have been allowed to continue in their service, and therefore no prejudice is caused to them by the advertisement in question. Full stop. It is also submitted that the petitioners can very well participate in the recruitment process wherein their candidatures would be fairly considered along with similarly situated candidates.
Another aspect of it is what they have stated in their affidavit in reply, the 16 persons have been absorbed. It is not the case, not a single person has been
Okay.
regularized.
No, they are agreeing. What is your problem?
No, they are just
Okay,
in their
please-
affidavit in reply that
Okay,
observation
okay,
with their law.
Sri Chaudhary has also disputed. Sri Chaudhary has, however, disputed that resolution number 5 was acted upon as no persons have been absorbed by the NIT. Full stop. Para. On the issue of the consideration to be made, comma, the learned counsel has submitted that for such consideration, comma, the input oblique cooperation of the MHRD is necessary. And in spite of, did you make request for to be?
Yes, Lordship. In
And in
our
spite of,
affidavit,
and in
our
spite of
affidavit-
request, comma, such guidelines have not been, such input has not been given, and therefore the consideration has been deferred, has not been able to be made. Full stop. The learned counsel has, however, submitted that in the affidavit filed by the NIT as mentioned above, comma, it has been stated that the stand of the NIT has been stated. Full stop. Para. Sri Gogoi, the learned CGC, has submitted that the NIT on its own can consider the cases of the petitioners in compliance of the order of this in compliance of the order dated 5/12/2012 in terms of the law existing, a law governing the field of regularization. Full stop. Para. The rival submissions have been duly considered, and the materials placed before this court have been carefully examined. Full stop. Para. Though the issue of regularization is no longer res integra and has been settled by the Honorable Supreme Court in, amongst others, the case of Uma Devi Supra, comma, in the instant case, there is an order of the Honorable Division Bench dated 5/12/2012, which was rendered after the judgment of Uma Devi 3 Supra. Full stop. This court has noticed that the division bench as such did not issue any mandamus for regularization, and the direction was only for a reconsideration, taking into account that the petitioners had served more than 30 years in the NIT and were still continuing in their services. Full stop. Para. For ready reference, comma, the relevant observations made in the aforesaid order is extracted herein below, page 46. Here, bro. Go take it. Having our go take it here. Para. This court has noticed that the aforesaid direction for consideration is also qualified by the observation made that if the petitioners were aggrieved, comma, they would be at liberty to seek legal recourse. Full stop. The aforesaid observation, comma, in no unambiguous terms would mean that such a reconsideration was or which was directed and for which a time frame was also given was a mandatory direction. Full stop. However, comma, in spite of passing of more than a decade, comma, such direction has not been fulfilled. Full stop. Though the learned counsel for the NIT has highlighted that the petitioners have been allowed to continue in their service, comma, the said aspect would not be connected or relevant to the issue which was in the first part of the order requiring a reconsideration on the aspect of regularization. Full stop. The learned counsel for the NIT has also highlighted the aspect that though input was sought for from the Ministry of Human Resource and Development, comma, it is only, and such input was not forthcoming, and it is only for such reasons that the consideration aspect is yet to be done. Full stop. He has, however, submitted that the stand of the NIT has been made clear in the affidavit. Full stop. Para. The pleadings in the affidavit is only with regard to the issue which has been raised in the court and to contest the writ petition. Full stop. The said stand cannot be construed to be a conscious stand, not to be a stand after consideration of the cases of the petitioners as directed by the Honorable Division Bench in the order dated 5/12/2012. Full stop. Delaying the issue of consideration is not only detrimental to the interest of the petitioners, but also to the interest of the university itself as, not university, institute itself, as it is not desirable that posts are to be kept vacant, as in absence of adequate manpower, comma, the functioning of the institute would be adversely affected. Full stop. Para. Taking into consideration the aforesaid facts and circumstances, comma, this court directs that where is Mr. Gogoi? The Ministry of Human Resource and Development would immediately issue a guidelines or issue a communication in indicating the guidelines to be adopted while considering the cases of the petitioners in terms of the order dated 5/12/2012, and based on the said guidelines, comma, the NIT Silchar would consider the cases of the petitioners in accordance with law and by taking into consideration and by taking into and also by taking into the aspect that the petitioners have rendered more than 30 years of service and are at the verge of their retirement. Full stop. The aforesaid exercise be completed as expeditiously as possible, and in any case, within a period of 45 days from today. Full stop. As directed by the Honorable Division Bench, comma, till the consideration is done, comma, the post earmarked by the petitioners where they can be, where they have a chance to be regularized, namely the post of what? Give the post.
Senior technician, senior assistant.
Technician and senior assistant, technician and senior technician.
Junior
The appointment has
assistant,
been made.
junior assistant,
And
senior assistant,
senior technician and
senior technician,
And
and technician are not to be filled up.
Also means senior technician and technician appointment has already been made.
Malo, there is a stay order, contempt also.
Appointment
That
has
is
been
why
made
I-
and that has been put to challenge in the
Your
notice.
lordship
So
has-
will not say you
Yes.
proceed in the contempt and last to kini ki kolu? No, nam no koba. Aba tara gor kini. Till such. The post where the petitioners would have a scope for their consideration are not to be filled up by direct recruitment.
Here in this case, lordship, basically they are challenging this advertisement. Now what will happen to the advertisement? Because the persons have already we have processed with regard to that. Is the pendency of the
You
requisition.
go with the other post. In your own interest, you have given 1 month, 45 days, do it within 15 days. We have said that recruitment only
No,
to those posts
but
will
the
not
thing
be
is that
done.
that observation should be there, lordship. If we take a finding or take some sort of decision with regard to their regularization,
Only till
then immediately we
consideration.
can proceed with that, lordship.
Only till consideration, whatever we said.
Yes, lordship.
After consideration, you go ahead.
Exactly.
Last one, any question or whatever?
Yes.
Tara go kini. Direction kini. Till the consideration is done.
Till the consideration. Yes, that will cover it.
But do it on your own interest, Mr.
Exactly. Exactly. We'll do.
I cure kane. I for
I thought that was this the institute has filed
My
that.
lord, that when interim has continued, they take the initiative to fill
in
up
view of
some-
the final orders plus no.
That is
Obliged, lord.
obliged. Obliged.
Okay.
This is a matter of dismissal from service without inquiry. They took time on last occasion for filing affidavit.
But we have sent our affidavit for vetting, we'll file it in 2 weeks. But
You file your affidavit. It's come for admission.
And-
Okay. Sri I. Borthakur, learned counsel representing the PHE submits that the affidavit in opposition has been sent for vetting and will be filed shortly. Full stop para. List after 2 weeks to enable.
My lord.
Huh?
On 6th, my lord.
Let them file affidavit.
No, my lord, I am, my retirement is fast approaching.
Okay, we'll
I am
fix it.
expecting something.
List,
from this.
let such affidavit be filed within a period of 2 weeks. Full stop. As requested, list on
6th of August, my lord.
today's 23rd. Yes, 6, we can have 6, 7th of August.
Seventh.
No, not 6th of August. No,
6th
not 7th of August.
Second of
Wednesday.
Miles.
7th August. File it before that.
May I please, Your Lordship? Here in this case, my lord, petitioner have challenged the transfer order dated 7/6/2024, my lord, and as per order date 27/6/24, my lord, the state is respondents is supposed to file their counter affidavit. my lord.
Here, here, my lord, my latest instruction is the petitioner has already complied with the order and he has joined at the new place on 28/6.
But we have challenged the transfer order,
Yes,
my
sir,
lord,
that-
and
that- okay.
we will contest it on merit, my
Yes,
lord,
sir,
as per
and-
my instruction, my lord.
So, my
So
lord,
let them file their affidavit, my lord.
my humble submission to you, lord, since he has complied with the order, there is no question of any interim order in this case. So let him file a representation against the order and then as per the honorable apex court.
No, he is not pressing for any interim order.
I am not pressing for any interim order, but I will
Let him.
pray for
after
disposal
complying
on
with
merit,
the-
my
After
lord.
complying with the transfer order,
And your
he
lordship
can- he
order
can-
is also
Now,
27.
we will make an observation that though there was supposed to be a consideration for the interim prayer in view of his joining in the new post, the interim prayer is not liable to, is not
No,
required
he
to be
can-
considered,
Has been rejected.
he can.
rejected.
On 27/6/2024, my lord, your lordship may kindly pay.
He's not pressing that.
And directing them to file their counter affidavit after perusal of the record, my lord.
Not called. Kindly see the last.
27/6/2024, my lord.
And now, my lord, he can.
No interim order is called for. Okay, no problem.
He can very well file a representation before the authority.
I have already filed representation before
He
the
want to
authority,
contest it on merits. Let him.
my lord, and I have.
You file your affidavit.
Lord,
Okay. Heard three I Alam Leonard counsel for the petitioner. Also heard three D Nath Leonard senior government advocate for the
for
the state respondents, whereas
1.4, my learned friend is appearing for the restaurant.
respondent number,
Special.
who is free?
District
District?
Commissioner,
Okay,
District Commissioner Kasar.
okay. For respondent numbers, 1, 3 and
1.4.
1.4, D Nath and P Nayak for respondent number 3. Full stop. 3 Nath, the learned senior government advocate has informed this court that the petitioner has already joined in his transferred post. And in any case, comma, the interim prayer was declined on the last occasion. Full stop para. Sri Alam, the learned counsel has submitted that the petitioner would still like to contest
Well.
the transfer order on merits.
Well.
Full stop para. In view of the above, comma, let the contesting respondents file their respective affidavits, for which 3 weeks' time is granted.
My
What about 5 has been served?
lord, I have already served my lord, and
He is not contesting.
it's
5 is not
required-
contesting.
not required, my lord, at this stage, since I have already joined at that. Although I have services completed, my lord.
You have been transferred from which place to which place?
Lokipur to Silchar, my lord.
How far?
My lord.
What is the distance?
Within the district, my lord.
What is the
For
distance?
subdivision to district headquarters.
What is the distance?
Distance is almost 45 kilometers, my lord. From
Only?
Silchar to Lokipur to Silchar, my lord.
What grounds have you challenged?
My lord.
What are the grounds of your challenge?
My lord, we have challenged on the ground that they have violated the notification dated 6/8/2013, my lord, for will not taken up the consent of the approval of the chief minister, my lord. Since, my lord, his appointing authority is the Secretary State of Assam, my lord.
No, that is
Petitioner is the inspector.
that is a legal issue. But what is the prejudice being suffered by you?
My lord, in fact, my lord,
How long were you in the initial place of posting?
I have already 8 months, my lord. Only 8 months,
Only 8 months.
my lord. That's why I have been, my lord, pressing for.
You have taken
One-
the approval.
Yes, yes, approval is.
Approval is there.
No, my lord, there is no approval from the chief minister, my lord. Only guardians minister approval is there, my lord, but I have also, in my
How
petition,
do
my
you know?
lord,
Have you
also
seen
challenged
the, it
this, my
seems
lord.
that you have seen the file.
My lord.
He knows everything.
When Mr. Nath is saying, who is the custodian of the file, that there is endorsement, how can you say that there is no endorsement?
My lord, in fact, my lord, as per our, my lord, impugn order itself, there is nothing written, my lord. There is no administrative exigency also not here, my.
That will
In
not
the
be
impugn order,
reflected
my
in
lord.
the
That's why
order.
we are challenging this, my lord.
That will not be reflected in the order. It will be reflected in the order sheets. Note
let them file their, my lord, affidavit, my lord, your lordship.
produce the records.
Yes, yes.
No need to file affidavit.
Yes.
If that is the only ground, why affidavit is required? We see the records, finish it off.
On the next day, my lord, it will be taken.
When can you get the records?
Record is with me, Lord, already.
Right now?
Right now, means today my name is not appearing, that is why I missed the case.
We could have disposed of.
Yes, Lord. On day before yesterday, I placed the record. That day also. it was-
Signature is, his approval is there.
Yes, Lord.
In
Lord,
fact,
we
my
have
lord, as per my instruction, my lord, there is no problem. And we have basically challenged, my lord, the notification dated 2013, my lord. There is a requirement of chief minister within 3 years, my lord. There is a requirement of for transferring the officers, my lord. Chief minister's approval is required, my lord.
They said that the approval is there.
But so far
These
as
are
my
factual
instruction,
assertion. If they are saying and Mr. Naik is confident, sanguine about it.
my lord,
then
let them
what is-
let them on the day after
as per the-
tomorrow, my lord, let them produce the record.
No, why should we disbelieve what
As per the
counsel is
relevant,
saying?
as per the relevant notification.
My lord,
It's the signature
my
approval of
lord,
the guardian minister, Lord.
on last questions, they have placed the record before your lordship. My
Where
lord,
is, what is the notification? Let us see.
27/6, my lord.
Let us see the notification. Which notification violated?
My lord, kindly peruse the impugn order, my lord, page 30.
Which notification violated?
Notification, my lord, is at page, my lord, 36, my lord.
36.
36, 36, my lord.
Yes.
Policy of transfer of shares, my lord.
Yes, yes. After careful consideration, it has been decided that henceforth approval of the chief minister is required. Yes, you produce this. Let us see if it was approved by the chief minister. Yes, when can you produce?
It's already with me, Lord.
Huh?
I can produce it whenever your Lord.
Okay, 3 weeks. We'll fix the
I'm
date.
not saying, Lord, that the chief minister approved, given his approval.
Then,
But as per the relevant notification, approval of the guardian minister is required. That we have obtained.
where is the notification
That
then?
notification
The
is also
notification
there.
is also NS, my lord, that. That's why, my lord, I am.
Where? Which one?
That notification.
Page 34, my lord, annexure 5, my lord.
34.
That is written, my lord, and original is, my lord, at page 34.
34.
Here in the last line, it written as demands of administrative expediency with immediate effect. But that notification is not suppressed by the earlier notification, my lord.
Cabinet is conveyed the meeting held on 7th ago. Pleased to empower GDC for transfer and oh, this 35 is the latest notification.
That was not suppressed, my lord, but it's only.
No, no, you're not suppressing. You're not suppressing. You have annexed. This is your document.
He wants to say superseded. And your lordship may kindly peruse the impugn order also, my lord, page 30, my lord.
Now, after this, where is the necessity for the approval of the chief minister?
My lord, kindly peruse the page 30 transfer order, my transfer order, my lord.
30.
30, my lord, annexure 3, my lord.
Yes.
In the interest of public health.
Yes.
In pursuance of notification dated Amendment 28/6/2023, Shri Vinayam Krishna, Inspector Food and Civil Public Distribution and Consumer Affairs of the Subdivision Office Civil, Block 2 is hereby transferred to the Food Public Distribution Consumer Affairs Silchar in the Office of the District Commissioner Kachar. In view of the above, Shri Amit Kumar Porua, Inspector of Food and Civil Supply Consumer Affairs Silchar Office, Silchar District Commissioner is hereby transferred to the Food Public Distribution and Consumer Affairs branch in the district office of the subdivision of the Lakshmipur Kachar.
Yes.
But here is there is no mention about the administrative expediency, my lord. Administrative, if required, my lord, that should be mentioned in the order, my lord, itself, my lord.
What is the meaning of the expression in the interest of public service?
In fact, my lord, administrative, when the requirement of a government servant is there, my lord, like situation or other situation, my lord, arises, in that case, they can transfer, my lord, for the administrative expediency. But here in my case, that part is absent, my lord. That's why I am praying for my lord.
So it's
for-
only on, in case of flood, transfer can be made. No transfer can be made otherwise. Flood or emergency, the transfer can be made.
But here in my order, my lord, there is no such
The-
administrative experience is there. Only thing is the
meaning
public service.
which
my
you are
lord.
supposed to
And-
assign is not the correct.
And
No,
so far as-
you may be correct in contending that there is no public interest, but the order reflects that there was an interest of public service. Let us see, we'll see the notification. But I think you are in a very weak ground.
my lord.
We
My
thought that the approval of.
Only prayer is that your lordship may kindly record, my lord, and then your lordship may pass the order.
Record is there. You have the approval of the guardian minister.
But our case is stand on 2013 notification, my lord.
13 will hold that. 13 has been the latest notification will hold this.
Since, my lord, it is not superseded, my lord, and I have been transferred within 8 months.
In fact, complaint was made against him for the chief minister. When chief minister forwarded the file for taking necessary action. It was only because it was in the month of March, in between the election. That is why no action was taken. Now an inquiry has been ordered and he has been removed from that place because it was his place of posting, lordship, where the entire corruption.
But in my reputation, my lord, I have also already stated all this.
Okay, we'll take into consideration.
My lord.
Yes.
Item 26, submission.
May I please over. Due to different state and between the deputy commissioner's office as well as the fishery department, okay, ultimately the service of the petitioner dismissed, okay, petitioner was dismissed. What happened in this case, lordship, the petitioner was promoted as senior assistant, lordship.
As senior assistant.
Yes, lordship. In the office of the research officer, Amranga Borihat, lordship, on 11/7/2016.
Eleven.
11/7/2016. He is 36, lordship.
Yes, thereafter.
And thereafter, lordship, he was the deputy commissioner office, lordship, the circle officer, Dispute Revenue Circle on 11/9/2019, lordship. He was, petitioner was directed to discharge his duty as a BLO, booth level officer under NRC.
As a booth
level officer under the NRC duty. Page 37. On 11/9/2019, later was circle office, Dispute Revenue.
37.
May I read?
Please read this.
Pursuant to the instruction contained in letter number dated 2022, issued by the Election Commission of
What
India.
is the date?
11/9/2019.
11/9.
Sri Santanu Kumar Deka, working as senior assistant of Office of the Research Officer, precise contact number so contact number is also there, is hereby appointed as booth level officer for polling station number so with immediate effect. He is performed to under mentioned duties as responsibility of BLO as laid down in the Election Commission of India guidelines, and duties and responsibilities are also there. What happened here? While he was discharging as a BLO under the NRC duty, his petitioner's salary was not released, and therefore he has filed several repairs on lordship, and ultimately on page 45, lordship, 11/3/2020, the additional deputy commissioner wrote to the director of fisheries Assam.
Page
45. Very good. Very good.
Yes.
With reference to the subject matter above, I am the enclosed here with a prayer portion along with enclosure submitted by Sri Santanu Kumar Deka. Regarding release of his monthly salary from the month of October 2019 to January 2020. It is for the kind information that Sri Santanu Kumar Deka has been engaged as field level officer under NRC updation project in Kamrup Metro District and discharging his duty regularly. You are therefore requested kindly to take necessary steps for release of the pending salary of the employee under your control. But since no steps has been taken, Lordship, we have approached this honorable court by filing WBC number 2431/2020, case 46.
Yes.
And this honorable court had order dated 15/6/2020, the operative parts, case 48. After hearing the counsel of the parties and on perusal of the materials available on record, this court is the view that if the service of the petitioner was utilized by the NRC authorities, which is for the lawful purpose, and if he had rendered the service, the petitioner should be entitled to his salary attached to the court. Accordingly, the present petition is disposed of with a direction to the respondent office, more particularly the respondent 1, to examine the claim of the petitioner and release the salary for the lawful service rendered by him from October 2019 to till date. This exercise shall be completed within a period of 1 month from the date of the receipt of the certificate copy order. And thereafter, pursuant thereto, Lordship, the additional deputy commissioner again wrote to the director of fisheries, case 49. With reference to the subject matter, I am to enclose here a copy of the order passed by this honorable court, passed by the Honorable Guwahati High Court in connection with case number so and so on the matter of release of monthly salary in respect of Sri Santanu Kumar Deka. It may be mentioned here that we already communicated to your good office by later number dated 11/3/2020 to pay the monthly salary of Sri Santanu Kumar Deka, senior assistant, as his service was utilized by the office for NRC related work. And pursuant thereto, the director of fisheries again wrote to the research officer fisheries Amranga, Lordship, directing to release the pending monthly salary. And thereafter, we have filed
Which page? Page 50?
Page 50, Lord. Since no action has been taken, Lordship, we have filed a contempt petition. Contempt petition number 622 of 2020.
Page?
Hello. 190.
622.
Yes.
2000?
2019. 20, Lord. 622 of 2020.
Page?
Case 190.
119. Yes.
Taking into paragraph 4, taking into consideration of the state grievance of the petitioner, this court filed the state order dispose of the petition with a direction to the respondent, more particularly respondent 1, to examine the claim of the petitioner and release the salary for the lawful service rendered by him from October 2019 to till date. It was also directed that the exercise shall be completed within a period of 1 month from the date of receipt of certificate. Thereafter, pursuant to the state order, an inquiry was held as regard the petitioner. From the inquiry report which has been enclosed, an affidavit annexure 4 to the affidavit in opposition filed by respondent, it shows that petitioner has been continuously absent with effect from 19 September 2019 till date. Further to that, at annexure 12 to the state affidavit in opposition, an order has been enclosed dated 7/12/2020, whereby the petitioner was dismissed from service on the ground of unauthorized absence from the duty. From the state two documents, it is clear that the direction passed by this court to examine the case of the petitioner has been duly complied with. Accordingly, the instant convocation is then closed. The closing of the instant convocation shall not preclude the petitioner from challenging the order, proceeding inquiry proceeding as well as the order of dismissal if so entailed. So during the pendency of that contempt petition, they have filed the affidavit. So only from that we come to know, the petitioner come to know that the petition was dismissed from the service.
No, the your initial appointment was in the fisheries
Fishery
department in 16.
Yes.
19, you were appointed as booth level officer.
Yes.
In the for NRC work.
Yes.
Now, your salaries would be paid by whom?
Parent department. Parent
Why?
department.
Why?
Because they are the parent department, Lord.
No, you see page 37, the appointment order. It's a kind of a fresh appointment, see? You are not deputed.
Yes.
So who will pay the salaries?
But Lord, during the pendency of this contemplation, they have dismissed us. We have challenged the dismissal order in this.
Understood. No, first, there was an issue of
Yes.
salary.
Yes.
They have dismissed because you have been termed to be unauthorizedly absent.
Yes.
Now,
But
you say that
our contention is that we are discharging our duty, Lord. The
now you are
communication which-
discharging duties as BLO in the
Yes,
NRC.
Lord. Yes, Lord.
Now, that was in the year 2019.
19.
Now, if you are saying that you are discharging your duties as BLO
Yes.
with the NRC and you are fighting for your salaries,
Yes, Lord.
as on the date of dismissal,
Yes.
where are you?
So, as a booth level officer, Lord.
Has is the NRC made party here?
NRC, no. But
Mr.
our
Kolita, where are you actually discharging your duties as BLO?
PLO by the appointed by the circle officer, Lord. The circle officer is the deputy commissioner.
Now, where are you actually discharging your duties after your appointment?
During Kamrul district, Lord.
Where are you actually discharging your
Yes,
duties?
Yes, Lord. That's why then look at the communication by the additional deputy commissioner. He has page 45, Lord. This is letter by the additional deputy commissioner, Lord.
Now, that was in the year 2020.
2020, Lord.
When did you find to be unauthorizedly absent?
The inquiry report, Lord.
No, which period?
From that period, from 2019 to from 2020. The inquiry report, page 51.
Yes, Mr. Chakraborty.
Now,
They are annexer
Welcome.
15 of petition lordship. Yes, he stated that he has served as a BLO lordship. In the statement, BLO lordship, he stated that as per the BLO appointed to be the utilized after office hours and cannot be appointed for the utilize their service either during office hours or full-time basis, Lord. It's not a full-time basis, Lordship. They have stated that he has appointed as a BLO, Lordship. And the BLO was appointed by the circle officer, this full Lordship. He has no power to appoint the employee of the Kamrup Rural Department. He is an employee of the Kamrup Rural, Lordship, as a fishery department, from the fishery department, Lordship. And BLO was appointed by the Dispute circle officer, this full Lordship. He is not authorized to appoint such kind of Lordship. And in the BLO circular, it stated that BLO is not a full-time employee at the time, full-time basis, Lordship. And Lordship, he has the, there are several so-called notice issued, Lordship. He has, did not reply the so-called notice, Lordship. There are several so-called notice issued, Lordship. Kindly see our FPTB in opposition, Lord. They have not replied any, Lord. After that,
Why is
inquiry
not
was
replied to the
conducted, Lord.
so-called?
The petitioner, no scopus notice was issued to the
No,
petitioner. The petitioner has not
kindly see
received.
our annexes.
Let me peruse the inquiry report.
Kindly see the annexes, Lord.
Inquiry report, Lord.
Page
Case 51.
five one.
51.
Lordship, moreover, Lordship, he was a habitual absentee from the Lordship from 2012, 2005 to 36 to 9, Lordship. Of 4 years, he was absent, Lordship, in the office, Lordship. That was, he filed, one writ petition, Lordship, and the Honorable Court directed.
But Mr. Chakraborty,
Lordship.
if you come to page 51, the first point, Sri Deka was continuously absent with effect from 19 September 2019 till date. But from 11th of September, he was appointed as BLO.
Yes.
How can he be present?
Not that BLO is not a full-time worker, Lord. BLO is working, Lordship, after the, you kindly see the circular of the BLO, Lordship. Kindly
Page,
see the circular of the BLO, page 113, Lord. 113, Lord. In the read, Lord.
yes.
Deployment of BLO, full-time in election office, Lord. May I read, Lord?
Yes, please.
Lordship, in pursuance of the office letter dated so and so dated 27/12 and 11/9/12, by which it has come to the notice that undersigned that some ministerial staff are still working as BLO or for full-time in election office. It has been already been clarified by this office that service of BLO appointed is to be utilized after the office hours, Lordship, and cannot be appointed for utilizing their service either during office hours or full-time basis. As per the instructions of Election Commissions of India, letter dated 17/7/12, Lordship, you are hereby requested to send a certificate that no staff is working as a BLO for full-time, Lordship. If any staff is still found keeping as a BLO for full-time, Lordship, no salary should be disbursed from the date of receipt of this letter, and names of such official be sent to intimating disciplinary action, Lordship, as well, Lordship. He is not intimating the fishery department also, Lord, that he is appointed as a BLO. He's not a full-time worker, Lord. Stated in the annexes, Lordship.
The page 71 is the constitution of the inquiry committee.
71.
Date 11 August 2020.
Hmm.
11 August 2020. And inquiry report was the 13 August 2020. Within 2 days, they have passed, inquiry committee has conducted their inquiry without giving any opportunity. And the so-post notice, which has been annexed with the requisition Lordship by when they have annexed that in the contempt petition Lordship, page 64, that was the to Sri Santanu Rekha senior assistant. No address is given.
But how do you overcome the issue that BLO post is not a full-time post? Even you we hold that the appointment was okay, good, but that's a post which is to be done
Now we are stand that Lordship, it is not that the BLO is a full-time.
No, he is annexed,
but
in the read petition, Lord.
we are basic that the circle officer has no authority. He is the deputy commissioner Kamru has no authority. Lordship may peruse the paragraph 6.
Mr. Kulta, we may not go to those aspects.
After that, Lordship.
Whether it was with authority or not,
No.
we will not find it. We may not find fault with the order of appointment. It's okay. We are not going to the competence of the officer who had appointed. But such appointment being of extra in nature, that you should not affect your substantial post. How can you claim that you are serving full time?
He was regularly, he is attending the duty, Lordship.
Where?
From the booth level officer, as a booth level officer.
That's not a full-time job.
But they have utilized their services as a whole time, Lordship.
No,
The
circular statement, Lordship.
the stand of the deputy commissioner office is required, Lordship, because now the paragraph 6 of Lordship, if the paragraph
Circular
6
statement,
Mr. Chakraborty, for whom? Yeah, for
I'm
whom?
appearing for all the fishery as well as the deputy commissioner.
Deputy commissioner is there.
Lordship, therefore, the last time, 2 occasions, this honorable court has directed the deputy commissioner office to file their affidavit.
They filed, he is representing the
Because
deputy commissioner.
then, Lordship, the paragraph 6, Lordship. Now, paragraph 6, the affidavit in opposition of the filed by the fishery department. Paragraph 6 and 8 and 12.
No, see, Mr. Chakraborty has shown a document as per which the work of a BLO is not of a full-time job. How have you rebutted that?
Yes, annexed, Lordship.
Lordship, paragraph 8, Lordship, 8 of the affidavit in opposition. The respondent has the fishery department is 125.
Yes.
The deponent states that the petitioner has stated to have approached the Deputy Commissioner Kamrup Metro, although he was an employee of the Kamrup Rural District, and is further reiterated here the authorities of Kamrup Metro District will have no jurisdiction over employees of Kamrup Rural District. As of the in paragraph 6, Lordship,
Yes.
5th line, Lordship.
Hmm.
The deponent states that purported letter dated 11/9/2019. They are disputing the letter of 11/9/2019, stated to have been issued by the Circle Officer, Dispute Revenue Circle, appointing the petitioner as a BLO is an absolutely illegal order, which is perhaps in connivance with the petitioner. The Circle Officer has no jurisdiction at all to appoint BLO, and that too without any intimation and making any request to the parent department. Then the Lordship has already read the.
And this letter was not even submitted to the concerned office. What kind of order was this?
But Lordship, Additional Deputy Commissioner also reiterated the same.
Additional Deputy Commissioner only directed for payment
And
of
he
salaries.
is appearing the learned, senior friend is appearing for the Deputy Commissioner office, government Lordship.
Yes.
The Additional Deputy Commissioner also reiterated that he is regularly working.
Now, did he perform, who is the ADC who had written those letters?
Senior friend, as well as he is also defending the fishery department.
As per the annexes of the 113 Lordship, WPC Lordship, yes, the BLO's working is already clarified, Lordship. He is not a full-time worker, Lordship. In the fishery department, Lordship, they have he is unauthorized absent, Lordship. And my submission is that he has one due to unauthorized absent, so cause notice was issued, that he did not reply the so cause notice, then the discipline action initiated and dismissal from service.
The Additional Deputy Commissioner.
Now, Mr. Kolita, if it is agreed in the bar that the job of BLO is a part-time kind of a job, which also, and you say that your services were utilized full-time. Full-time. Then how did the ADC write to the Director of Fisheries for payment of salaries?
Lordship, the ADC, now if the learned senior panel is saying that the ADC also in connivance with the petitioner, he is writing this letter, then he cannot appear for the, because yours same, Lordship. Paragraph 6, Lordship.
No, you come to page 45. When were you appointed as field level officer? Which order?
Page 37, Lord.
Page 45. Come to 45. When were you appointed as engaged as field level officer? Which order?
11/9/2019.
11/9?
2019.
Page.
As a page 37, as a boot level.
That's a different
Maybe
post.
some.
What may be? He writes that you have been engaged as field level officer. Yes, who is this additional deputy commissioner? Mr. Chakraborty? Who is this person? At page 45 as well as page 49. Same person. You inquire who is this officer
Not.
and get an explanation from him.
No.
Where did he get the expression that he was working as field level officer?
And what is the regularly, Lordship? And defines, Lordship, is the petitioner was parent posting is at Amronga, Lordship, Borihat. And this letter from Kamrup Metro, Lordship. He regularly.
So I obtained that instruction, Lordship.
And these letters, both these letters. For second one is not even dated.
Second one, Lordship, page
49. There is a date in the endorsement of 5/8, but there is no date in the letter.
5/8.
5/8 is the endorsement by the dealing in charge. There is no date.
Last Lordship, 5/8.
This is not the date of the letter. This is the date of the endorsing dealing assistant who puts his signature below the officer's signature.
Lordship, my submission is Lordship, he was habitual absentee from office, Lordship. On earlier several occasions, he was absent from the office, Lordship. And after that, they approached the court, Lordship, and after the court directed to reinstate the service, Lordship. And department has, Lordship, sympathetically ground that he did not take any strong action, Lordship, and reinstate his service, him to service, Lordship.
And you say that you have been engaged full-time. BLO has been written as FLO, that raises a serious doubt. Then you come to page 45, the last, how you have been described. Shantanu Kumar Deka, Senior Assistant, Office of the Subdivisional Research Officer, Fisheries. You are not there.
But Lordship, last line was, has been engaged as a field level officer.
That we have seen. Come to the copy mark.
Well, Lordship, the scan of the deputy commissioner officer is required. Lordship. Last two occasions also, this on our court, they paid for time.
The Deputy Commissioner, Mr. Chakraborty has said that you are not, it's not a full-time job.
Lordship.
Who has filed the affidavit?
Fishery Department, Lordship. Respondent number, Lordship.
You take instructions.
Lordship.
You take instructions, who is this particular ADC? And you also make, to get instructions from the office of the Deputy Commissioner. You may file affidavit, you may not file, but you get the instructions in writing. Because he has made a categorical stand, taken a categorical stand that he was engaged full-time as booth level officer.
But in the annexure state,
Field officer. Who's the ADC? Okay. Heard 3K Kolita Leonard counsel for the petitioner. What's the para? Though affidavit in opposition has been filed by the respondent number 4, the Fisheries Department, comma, the stand of the office of the Deputy Commissioner, Kamrup M, would also be necessary. In view of necessary, full stop. Such necessity has occasion as there appears to be certain discrepancy in the facts, full stop. While the Fisheries Department in their affidavit has contended that the petitioner was an habitual absentee supported by a document that the engagement of BLO was not a full-time one, and such engagement is to be done after normal office hours, comma, the learned counsel for the petitioner has asserted that he was engaged full-time as a booth level officer, full stop. Juxtaposed, comma, there are two communications by the ADC Kamrup dated 11/3/2020 and 5/8/2020, which have been addressed to the Director of Fisheries, directing on the issue of release of salaries. Full stop. In both the communication, no, in the said communication, comma, or in the second one, I think. In the first communication, comma, the petitioner has been termed as a field level officer, and in the second communication, which does not bear a date, comma, there is no reference as to the job, as to the engagement, as to the nature of engagement of the petitioner in the office of the NRC. Full stop. Para. Instructions are also to be taken as to under what capacity and background and circumstances the aforesaid two communications were issued by the concerned ADC, including the aspect as to whether such communications were issued with the approval of the competent authority or not. Full stop, para. List on on 12th of August. You take copy of this order.
Lord.
And identify the ADC.
Lord. Apply. Apply.
Meet the Lord.
Working.
Yes.
I am not able to stand for a long time. But if I will to make some but
No, we can have it some other day. You take 16 matter. It's an old matter. We'll have it on Thursday. Right. You take rest Thursday. What is the matter? MSCP matter. Oh.
My learned is speak that he can make commission by sitting on
No,
the chair.
no, we may not have too much of time. Let him relax and do it.
That's-
Thursday. We'll have it on Thursday. Paucity of time may not permit the matter to be taken up today. Full stop. As requested, and considering that the matter is of the year 2016, list for hearing on Thursday.
Public.
Apply.
এটাটা কি আছে? এটার লগত কানেক্ট হয়েছে, হ্যাঁ? 9 or 10 মেনশন করছেন। ও মহন্ত, আচ্ছা আচ্ছা। Yes, Mr. Sinha.
Yes, my lord, it's a dismissal from service, my lord.
Yes, please.
Yes, my lord, we may take, my lord, the affidavit in opposition, my lord. Because they are all the documents they have enactment.
Now first, let us know few facts.
But the thing is that the petitioner,
Just a minute, let us
Yes.
note some facts. Okay. You are appointed as what?
is appointed as a constable GD constable, man.
Where, Assam Police?
No, in SSB, man.
oh. Constable GD.
Yes, man. As
SS
per order dated 29/5/22.
SSB.
SSB, man.
What is the full form of SSB?
That Sashastra Sima Bal. Sashastra Sima.
What is the difference between Sasastra Sima Bal and Sima Suraksha Bal?
That's I do not know about the
You do not know?
Yeah, no, I don't know.
You do not know the functioning of SSB? What is SSB?
The SSB, they are functioning as a.
When was SSB born?
That's I do not know. I cannot.
You have not asked your client.
But I have newly engaged in this case.
Your newly engagement is not a reason. Why was SSB created? For which part of the country? What was the immediate need?
Now it is. I have to quite empty my life in this regard now. At this moment.
Okay. Let us concentrate on the dismissal. Okay. Your constable, when were you appointed?
On 29/5/22, 2002.
29/5/2002.
My lord.
Then
my lord, he has
posted where?
Posted at Tezpur, Assam, in Tezpur.
Okay.
Thereafter, the entire my lord department has been shifted to Bihar.
It is
The-
14 Battalion SSB.
Unit has been.
Unit has been transferred to Bihar and in Joynagar, my lord.
This is the what battalion? 14th.
14th Battalion.
Okay.
Then, my lord, the petitioner was granted leave. Then he has availed the leave. And while availing leave, my lord, he met with an accident.
Yes.
He met with an accident, and accordingly, he has undergone medical treatment. Firstly at Tezpur.
What
thereafter-
accident? What was the injury?
Injury is the hand injuries, my
Hand.
hand injury.
Fracture or what?
That is something like that, but it's not curing. That's why, my lord, the thing has taken long period, my lord. I'll be coming.
No, what kind of injury? Was it a fracture or sprain or what?
No, that could not be detected, my lord, properly. That's why the matter has been referred to AIMS also.
Okay.
Yes, ma'am. So he was initially, my lord, given treatment at Tezpur, my lord. Thereafter, Guwahati Medical College Hospital. Then thereafter, he was treated in AIMS at New Delhi.
Hmm.
And thereafter, his case was referred to Patna also, Bihar. Patna for bone injuries and something like that.
Okay.
So bone injuries. Thereafter, my lord, the matter was decided to refer to before Belor, my.
Okay.
So in this time, my lord, the proceeding has been drawn by the department that he has been deserted from service.
We order dated?
Reason is that he has not joined in the
Order dated. Order dated.
Yeah?
Order of proceeding.
Order dated 21/5/07.
Page.
21/5/07.
Page.
Okay. 44, 40. No.
44.
No. 39, 40.
$39, 40. Okay. This is the charge memo.
Yes, ma'am. In the later on the text 40, madam, therefore, as power so and so, last paragraph. The undersigned has passed on a removal from service. Page 40 from bottom second paragraph.
Where is the charge memo? This is not the charge.
Charge memo is not, my lord. That is the case, my lord. Case here. Nothing has been passed because he was going for medical treatment. That is our case. From here to here, here to there. That is our treatment. Now, whether communication has been made about disciplinary proceeding. Enquiry report is also not there. That's why, my lord, I have gone to that affidavit of opposition where the documents are there.
Okay, we'll come to that now.
Yes, ma'am.
Now, this is the order of removal of your from service.
Yes, from service.
Impugned order.
Impugned order.
Did you prefer any departmental appeal?
Yes, my lord.
You preferred?
Yes.
What happened? What happened?
That was also, my lord, your lordship will find page 50.
Dismissed.
Yeah, dismissed. 50. Page 54 is the, my lord, relevant part. Last paragraph. Now, therefore, the Director General SSB, after carefully examining the instant appeal preferred by appellant after a lapse of 9 years and rejected the same.
Just Sharma, you said, take your seat. We'll come to you.
Right. So these are facts of the case, my lord. Now, my lord, we for documents and all, we may take to go to affidavit in opposition, my lord. Because we have no such document.
I think rest of the matters will not have time to take up. Rest of the council may leave.
I have humble privilege taken the concept of my significant, my lord. Can it be next Thursday, my lord?
Mr. Bora,
If you have taken the concept.
next Thursday only have said,
We thought 25th, my lord.
this Thursday,
No, this Thursday,
oh,
my lord.
next week.
Next week, lord.
Okay, okay, next Thursday, okay. Etu kori jiba na? You want on 1st of August?
First of all.
Okay. Kone marisil ba? Okay.
Public.
He'll give dates.
Fine.
Urgent matters, he'll give dates. Otherwise, dates will be given. Don't worry. Yes, page.
Affidavit in opposition. Affidavit in opposition.
Page.
Yes, my lord. Your lordship will find. All the department, they have know that I was undergoing, the requisition was undergoing medical treatment. Then your lordship may kindly come to Annexure C. Annexure C, page 29 of affidavit in opposition.
Yes, please.
Yes. Reference your application dated 25/6/04 for commuted leave with effect from 23/5/04 for your treatment. Your case will be considered on your joining for duty along with medical fitness certificate in form number so and so, along with all other documents like prescription, case memo, etc. so and so.
Yes.
Now, then we may go to the next annexure, my lord. Page 31. Number so and so Raju Das of this unit was involved in an RTA on 28/4/2004 and developed right-sided JRB's paralysis. MRI findings are suggestive of evaluation of RT8 G007 and T8 from the spinal cord. He was treated at Guwahati Medical College Hospital, District Disability Rehabilitation Center, Tezpur, and Patna Medical College Hospital. Now, PMCH, Patna Medical College Hospital, has referred him to AIMS, New Delhi. Accordingly, he is sent to your kind attention for further necessary action in this regard. This is written by my lord, Commandant 14 Battalion, so and so, to the Medical Superintendent, All India Institute of Medical Science.
Yes.
Now, my lord, next paragraph also is supporting document 26/10/04 on so and so. Next annexure, page 32, my lord. So and so Raju Das of this unit had sustained multiple injuries in road traffic accident on so and so. Subsequently, he was treated at Guwahati Medical College Hospital, District so and so, Tezpur, and Patna Medical College Hospital. Currently, he has paralysis of right arm due to RT right branchial plexus injury, for which PMCH has referred him to AIMS, now New Delhi. Therefore, he is being sent to New Delhi with request to extend any possible help from your good office. So these are written by Commandant.
Yes.
Now, page 36, that he is under treatment at AIMS. This shows, those documents annexed by the respondent shows that he is undergoing treatment. He was undergoing treatment at AIMS. Raju Das is under treatment at Neurosurgery Unit 1 and he has been advised admission. He has come from Assam. for his treatment. At present, he has been staying in a hotel, so and so, so and so. Large amount, I shall be grateful if you please. Then we can skip to my lord.
This is the date. What is the date? 9/11 what?
Date is my lord. 9/11. It should be 2005, my lord. 9/11/2005.
Okay.
Then, my lord, your lordship will find the letter issued from department is 41.
Yes.
Memo rejoining notice issued by the assistant commandant Eco 14 Battalion SSB Kunali Bihar. And information the subject is rejoining notice as information received from battalion headquarters by the commandant 14 battalion so and so that you were referred to AIM New Delhi by P. Patna Medical College Hospital for better investigation and treatment of your ailing hand. In this connection, you should be kept the communication with the competent authority regarding your progress of treatment, but you had failed to give intimation for the same, either to battalion headquarters Joynagar or to this COI headquarters. Hence, you are hereby directed to rejoin your duty at battalion headquarters of the COI headquarters, forthwith on receipt of this memo along with fitness certificate and also other relevant documents, failing which a disciplinary action will be initiated against you as per existing government instruction. This is on 27/8/2005. Similar notice next annexure T10/2005 same notice was issued page 42. Similar kind of notice. Then your lordship, this is the annexure L, page 43. Since they might have not received any information from the petitioner, so the steps they have taken by order 310/2005. The following board of official constituted as under will conduct a court of inquiry to investigate into the circumstances under which number so and so Raju Das E. Koi, 14 SSB Joynagar, Bihar, who is overstaying from leave without any information with effect from 11/5/2004 to the competent authority beyond 60 days and to declare him as deserter. The place, date, and time of assemble to be fixed by the presiding officer. The next annexure is the memorandum has been issued by assistant commandant. So court of inquiry to be held against the petitioner by this memorandum. The last paragraph will comment. Hence, you are directed to report back to COI so and so Joynagar on or before 20/11/05 without fail. Also, you are directed to submit all the relevant medical so and so. That was repetition of earlier. Prior to that, your lordship will find, hence, in connection with court of inquiry, your presence is urgently required for recording of your statement as well as to conduct the court of inquiry as desired by the higher headquarters. Then, my lord, submission of court of this, all these things, the petitioner did not know anything about this fact. Whether these things are communicated, though the letters, particular letters are issued, then court of inquiry report has been submitted. That is page 45, by the assistant commandant to the commandant. Submission of court of inquiry report. Please find enclosed here with the court of inquiry report against so and so conducted by so and so. Now your the next page is important one, page 46. An order has been issued. Passed. Whereas a court of inquiry under CRPF rule so and so, so and so, so and so was instituted, hired commandant letter number so and so, so and so, so and so, so and so, so and so to investigate the circumstances under which number so and so Raju Das of this battalion is overstaying from leave without any permission or information of competent authority beyond 60 days of leave. And whereas the court has substituted the court of inquiry report, submitted the court of inquiry report along with the findings by letter number so and so, so and so, the commandant 14 Battalion Joynagar, having carefully perused the court of inquiry proceeding, agree with the findings of the court. Now, therefore, under rule so and so, Raju Das of this battalion is hereby declared deserter from 14th Battalion Joynagar with effect from so and so, so and so, so and so. Now, there is whether court of inquiry can be held under rule 31 ABC. This also to be examined by your lordship. Whether the petitioner's case covers under this rule. That is CRPF rule 31 ABC. Then Annexure P memorandum, which I did not receive any time. (22,466).
06.
Yes, sorry, 06. Sorry. And the undersigned proposes to hold an inquiry of so and so, Raju Das, so and so, so and so, so and so, corresponding to Rule 27. The substance of imputation of neglect of duty oblique remissness in the discharge of duty oblique disobedience or misconduct in its capacity as a member of the force in respect of which the inquiry is proposed to be held is set out in the enclosed.
Mr. Sinha will continue.
Yes, my lord. Yes, my lord.
Maybe tomorrow, no, day after tomorrow.
Yes, my lord.
We'll mention this matter will take as a first hearing item.
My lord.
Okay. Day after tomorrow. Make a mention, both of you come, first hearing item.
Right.
After the whatever admission motions will be there, Thursday, that
Yes,
should not
yes,
be.
my lord.
Okay. What is your stand?
My lord, our stand is that, my lord, he was given the leave, committed leave, then thereafter he was made accident, my lord. Thereafter he has taken, my lord, different treatment, also department also helped him to treat in different, even in aims of my lord. But he has not informed regarding his health status, my lord, fitness. Thereafter, my lord, department also taken some reasonable notice, my lord. 3 reasonable notices were sent to the present petitioner, my lord, but he never responded.
Was it served upon him?
My lord, that is here, my lord. Our petition is here, my lord. Here.
No, you are correct in contending that though he was under treatment, his duty was to inform his progress,
My lord, my lord.
which he has not done. So you must have thought that he is not interested in coming back to join.
Right.
So he had given a number of rejoining notice. But taking into account the nature of the injuries which he is complaining, in a given case, it may not be held to be very unreasonable not being able to inform you. And if the notices which you had sent, we have found that the notices, the address is either of Tejpur.
Right.
But he was in Ames, New
Undergoing
Delhi,
treatment.
New Delhi and Vellore. Was
Right.
he actually served with the notice?
Notice was, my lord, here.
When did you actually, where are you now?
Now I'm at resident now.
Tejpur.
Yeah.
What is your age? What is your age? Are you medically fit to discharge your duties?
Because fitness certificate, I think he did not get. Now,
Then why didn't you convert the, if he's not able to perform his duties, then
Yes,
we
yes.
cannot force you to have him in your rank, but you can definitely reconsider and pass some orders that to discharge him from his duties and give some pensionary benefit.
Yes. My lord, here, my lord, but he has filed appeal, my lord, before the DIG, my lord. First, he has prepared appeal before the commanding officer, my lord, rejected. Thereafter, he filed DIG, my lord, before DIG after 3 years from the removal of service, my lord. And thereafter, it was rejected, DIG. Thereafter, filed DG before it, after 9 years. After 9 years, he has filed appeal before the DG, my lord, then DG also rejected.
No, you see, any case we are not directing, interfering or directing reinstatement of a person who
My
is not fit to discharge his duties because of medical grounds.
lord.
But you can reconsider his case if the injuries sustained by him in the RTA, road traffic accident, is found to be genuine,
Right.
which appears to be genuine
Right.
from your own document.
Right.
Then you can reconsider and convert this penalty into such an order that you do not retain his service as at the same time he gets something from you. What are the you can take instructions.
Right.
What alternative steps can you take without there being a penalty order?
I will have to take instruction in regard.
And Mr. Sinal, you also take,
Yes, my lord.
if we are inclined to interfere with the removal order,
Yes, ma'am.
what can we suggest? Because we are not directing reinstatement.
No.
Yes, and
Not that.
reinstatement, of course, my lord, is a long time has passed.
Paucity of time, huh? List on Thursday.
For this, my lord, instruction, my lord.
You check the rules, you have the rules and have a telephonic instruction. We are not saying that based on the instruction we are going to pass. We are just trying to explore
Right.
if something can be done for the petition.
Right.
Because his injuries appear to be genuine.
Right.
That is the only, if there was any other reasons, then probably we would not have taken this stand. But injuries appear to be genuine. Okay.
Obliged.